My lord, there is one matter related to 10 marks. On 6th November, it was mentioned, and as per your lordship's direction, this matter was to be listed today, but it had not come in the list. My lord,
Matter whatever order is passed will cover you.
my lord, if the point, if the my lord, if the points in the writ petition is not placed before your lordship today, then with this all matters, then it will be some loss for the petitioners and the applicants, my lord.
Wait. Please wait. Matters will appear in due course. Do not worry.
My lord,
Same thing, 10 marks.
I also, my lord,
Same matter.
addition of party in our matter, my lord.
The main matter is not their addition of party.
My
My
lord,
lord, is the oldest.
my lord, this is the oldest matter, my lord. It has been filed in September, my lord.
Yes, there are other matters also.
Yes, but this has not been.
First matter.
This is
It will appear. Give the number. They can
my lord,
not come. It has been
my lord, I'm sick.
my lord.
requisitioned. They can answer a WB number 10 in same WB number.
Yes, same WP number.
Lordship,
Same
No,
WP
my
number.
lord, kindly take the matter today, my lord.
24th in this month. Earlier page fixed the matter on 24th in this month. Seeking direction so that it will be appear on 24th.
Advance direction.
My lord, come to know that file say already sent down. It will
What
take
can be done? If it has sent down, it will come up.
My lord, I'm seeking leave to urgency to file the writ petition. My lord,
Urgency.
this is the OMR regarding the second SLST discrepancy in the OMR. 17th is the possible date for interview. My lord, if your lordship kindly allows this to
Discrepancy in OMR, 1 second. What is the issue?
OMR regarding the bubbling issues.
Yes.
My lord, kindly keeps it on Friday, my lord, so that it can this 48 hours requirement kindly be condoned, leave may be granted so that it can appear on Friday. And I can serve on Thursday and can Friday.
Thursday is tomorrow.
No, I can serve it. But kindly keep it on Friday, my lord. That is right. Because 15, 16 Saturday.
Okay, other matters have been fixed. I will not
Then
fix
tomorrow,
it
my
on
lord,
Friday.
15, 16 Saturday, Sunday.
Nothing doing.
That is the difficulty.
Saturday, Sunday, let it remain.
There is Monday, my lord.
18th,
17
Tuesday.
possible is the date for document verification.
Whatever will happen, will happen.
My lord, kindly 17th, my lord. 17th, my lord, at least, my lord, because
All right, 17th.
leave may be granted.
My lord,
giving the number for 24.
Please don't give the number. Wait.
my lord, kindly permit that.
Panel cancelled, my lord, some teacher has been instituted in their previous school, but they have been posted 150 meter away. But you will not take a bunch of matters, you will not. They have this similar matter, but can you
Again tomorrow.
so same issue, my lord, same issue. One matter decided, everybody will go.
All right, tomorrow.
My lord, kindly permit that the matter will be heard today, my lord. My lord,
Madam,
kindly
the
seniors
matter
will be
is not there
appearing.
in the
My lord,
list.
The supplementary
Please
list,
wait.
my lord.
my lord, kindly, my lord.
Please wait. No.
Lordship, a matter filed before the Pujo vacation and the matter till date is not in list. So, Lordship,
What were you doing when all matters were allowed for inclusion? You cannot come up any day. Right? So please wait for your turn next month.
Lordship, 6th of November.
Lordship, the unmarried daughter's pension, Lordship, it was heard and directed the elder sister to file an affidavit before this court. And it was directed to appear on 7th November. Lordship, it has not been listed. Lordship, kindly consider.
Yes.
I am seeking leave to file this writ petition, my lord. Identical writ petition, you will also be pleased to fix on 14th, my lord. This is, my lord, regarding the getting of 10 marks for prior teaching experience with regard to the contractual teacher in central government school. Your lordship has been pleased to fix the matter on 14th, my lord. This matter will be kindly taken up with
This matter will be taken up on the 18th. Whatever order is passed on 14th will cover you. Right? 18th it will be taken up.
My lord, there is another matter. On the earlier, in the earlier occasion, earlier bench had passed the order that it will come in the list on 11th November, but it has not come. My lord, this is an urgent matter. The upper primary selection process and the counseling is going on.
Yes.
And there are two matters was to be listed yesterday, but it has not come.
Taken into it.
The notice had been
All right,
served.
call the list, please.
Grateful.
I was sending leave to file an petitions pertaining to the determination of the circuit of service. Being affirmed, unless the leave is given, it will not be affirmed.
Circuit bench is not there this week. What is the urgency?
Urgency, the recommendation was made, appointment letter was given. I was not allowed to join the schools. Only the ground, the validity period of 90 days expires.
Yes.
The court directed to consider and giving the
No,
observation.
I am not giving leave. File it in the circuit bench. It is not so very urgent. The issue is already being decided. It is urged before this court. So whatever will happen will govern you. File it in the
It is being considered.
circuit bench. Yes.
May it please your ladyship, beg to appear on behalf of the applicant in the contempt application. There was a direction for service. Service has been effected, my lord, upon all the contemners.
Is anybody appearing for the contemptor?
Mr. Bandyopadhyay is appearing. Yes.
Yes, your lordship. Your lordship, Mr. Bandyopadhyay is leading me, your lordship. I appear on behalf of the speaker.
Oh, he's coming. What is the violation?
But I'll be praying for issuance of rule of contempt because
what is the violation? Tell me.
Your ladyship kindly takes the order, solemn order dated 28th of August 2025 at page 16.
Yes.
Here, my lord, the learned Advocate General had filed a report whereby the speaker replied, my lord, to the query of the Honorable Court via the Secretary of the West Bengal Legislative Assembly. Now, there it was stated that all the MLAs, my lord, the members of Legislative Assembly are being treated equally and no one is being permitted to enter inside the premises with the security, personal security officers. Now, on the basis thereof, my lord, the writ application was disposed of, recording at para 9 that all the members of the Legislative Assembly shall be treated equally. And before that, if your ladyship kindly also takes, my lord, para 7, 5, 6 and 9, para 7 especially, as the Secretary West Bengal Legislative Assembly has intimated the learned Advocate General that the security arrangement is maintained equally for all members of the Legislative Assembly, irrespective of their political affiliation. Accordingly, this court is not inclined to proceed with the writ any further, though the maintainability was sought to be urged, such and such. The instant writ petition stands disposed of with the observation that all members of the Legislative Assembly shall be treated equally. Now, this solemn order, my lord, was immediately communicated on the 29th of August. The communication was made, my lord, to the Honorable Speaker, the Secretary of the West Bengal Legislative Assembly, the Director General and Inspector General of Police, the Commissioner of Police, as well as the Director of Security, stating that this is the solemn order and you are hereby required to act strictly in compliance with the order. Now, pursuant thereto, at page 20, the Assembly House published a notice dated 30th of August that no one will be allowed to enter inside the assembly premises with their security. Now, this happened on the 30th, but peculiarly, my lord, on the 4th of September, I have pleaded it in para 5 and 6 of the contempt petition, but no one was allowed, my lord, to enter inside the assembly premises with their security, my lord, the legislators of the opposition, party in opposition, whereas, my lord, the MLA, my lord, from Bhawanipur Assembly constituency, who also consequently happens to be the Chief Minister of the state, so she entered the assembly premises with an entire security detail. There was no obstruction, nothing, my lord. We have also enclosed, my lord, at page 22, my lord, the newspaper report, and we have also, my lord, furnished, my lord, along with the petition at page 23, my lord, the pen drive containing the video footages, my lord. So this is, my lord, I say, my lord, it's an attempt, my lord, to mislead the Honorable Court, my lord. It's a deliberate attempt because our case was, my lord, throughout in the writ application.
All right, I have followed your.
My lord, Learned Advocate General will like to address your lordship, my lord, on this contempt application. He was requested to, my lord, either pass it over if it is possible for your lordship, my lord, because it's an original side matter, my lord, we are conscious of it. Or, my lord, if your lordship takes it in the coming week, my lord, or Wednesday or Thursday, because he's addressing the adjacent court, my lord. He's on legs.
My submissions are very
as
limited,
far as for the contempt number 1 mainly, 2, 3, 4, my lord, we'll also address your lordship, my lord, may not have any role in the contempt at all. Because your lordship had heard a bit of the matter, my lord, and the powers ultimately will lie with
the order is very clear.
Yes.
It was relying upon the Advocate General's submission that this ensure that this order is complied, nothing more.
But we'll come back with our, my lord, kindly takes it next week, my lord. This probably will require.
I'll be praying for issuance of a rule, my lord.
When somebody is appearing, then what is the use of the rule?
Very good.
Third submission made on behalf of the petitioner. Stuff. Learned advocate representing the alleged contemners seek accommodation on the ground of the Learned Advocate General. Stuff. Next Wednesday,
Wednesday.
19th.
Grateful.
না না আমি আগে বলে নি তোমাকে তো তাড়াহুড়ো
But in any event, the learned advocate general will come and seek the.
No, I'll make my
No,
prayer. You
first
don't
is
make
for-
the prayer on my behalf.
In terms is no, I am just indicating the law. You are not supposed to
No, no,
indicate
what you
what I am
want?
indicating.
What you want?
We'll come
No,
back
but,
on the Wednesday, my lord, and we'll
My lord,
make our
the
submission.
procedure is, my lord, they will come and, my lord, seek for an affidavit. So, my lord can, my lord, direct filing of an affidavit.
If required, we'll seek on the next day, my lord.
Not today. Let us not jump steps. Let
Very
him
well.
come.
Grateful.
I appear for the
বলছি যে এটা অডিয়েন্স তারপরে এক নম্বর আমাদের
but I have given notice to the other side. The last day of the
Well, in this
my
matter,
affidavit service.
Mr. Bari is appearing on behalf of the respondent number 4, 5, and 6.
School.
But I'm school. But I'm praying but short passover. But he's coming. He was here.
Let me start then.
Let him start.
But I am questioning
The
the
state.
the state has no role in this matter because the de-getting school where I am working, the difficulty is
Mr. Bhattacharya, please. As it is, the courtroom is very small and with so many people, it becomes difficult. Yes.
I was appointed in 2010 as a teacher. I was confirmed in 2014. The difficulty is but I am not on that. I am on the issuance of show cause notice and the charge sheet. Kindly turns to page 50 to 97, page 50 once. But what is my challenge in this petition? Charge sheet, your lordship will find at page 50.
Yes. Charge sheet.
Your lordship will find page 51. Then kindly turns to page 52. But the charge number 1.
What is the stage? 7th April, I can see this.
Yes. Thereafter, continue. I question this charge sheet on the point. Kindly turns to the charge number 1, last line. So, it misconduct on your part in terms of para 10 of GO number 214 dated 8th of March 2018. Wait a minute. Now, I tell you, lordship, this is the rule for disciplinary proceeding. Kholo na.
Yes.
For the teachers working in the government aided institutions. This is a de-getting school. This rule of 2018 disciplinary rules is not applicable in cases of de-getting schools. This is number 1.
I need the state. Who's for the state?
May I show the law first?
Who is for the state?
I have given this to the other side. But kindly see who appeared for the state. Order sheet is
No, order sheets are over here.
Well, the AOR has been put on notice.
Give one more notice. Come back. Please come.
Can I interview? No, let him give a notice. I will appeal. Kindly keep it in the list.
Okay.
I will.
Accommodation has been sought for on behalf of the respondent numbers 4, 5, and 6. Stop. Release the matter next Wednesday.
Next.
This one number 4, 5, and 6.
দিয়ে দাও চিঠি দিয়ে দেবে
Side mentioning. That appellate side mentioning.
Yes. Item 1.
Mentioning.
My lord, I am appearing for the writ petitioner. The writ petitioner has requested to withdraw the writ petition.
Let me see the request.
Yes. Yes, Your Lordship.
Are you the advocate on record?
No, Your Lordship.
Iggy? Let me see. Release. Non-prosecution. Dismissed as not pressed. Yes. Give your name.
Lord-
Your name.
The slip.
Non-prosecution. Application which করা
Petition, if it is disposed, consequently all application stands dismissed. Yes, two.
I appear for the petitioner, same. But this is my
Not press. All right, not press.
the written instruction.
Yes.
অন্তিম ভট্টাচার্য
I am appearing for the Service Commission. But I think Mr. Bhattacharya, the matter which was arguing, if Mr. Bhattacharya is there, it can be taken up that first. The matter which Mr. Bhattacharya was arguing.
He is arguing same thing. Is it?
Yes.
It's the same matter.
Same matter, my lord, item number 3, 4, that is filed before, my lord, even start of the online application.
No, I have no difficulty. I am saying that only if the Mr. Bhattacharya which has comments, whether you will lordships will take up same branch, same list.
Yes.
Mr. Bhattacharya is here now. He said he will argue.
Court number 13.
Okay, you can start. There's no difficulty. I had a talk with him.
He'll come, he says.
But only one thing that your lordships wanted to know whether these points have been taken in the Supreme Court or not.
Yes.
Well, kindly see this. Look, give it. See, আমার এটা খুলে দাও।
Prepared a compile
Judge.
all right. Orders.
All
right.
And this is
Is that the compilation?
This has got all the orders of the Supreme Court.
Or Supreme Court and
The rules.
and Miller
All right.
কোন প্যারাগ্রাফ প্লিজ আমার কাছে তোমার কাছে কপি সফট কপি দেবে মানে কাইন্ডলি টেক দিস
Is this the same compilation? One has been handed over. This is separate. Are the orders the same possible?
compilation কত
page 180.
page 181 page 181 of the compilation তাই তো কাইন্ডলি কাম টু গ্রাউন্ড কোথায় আরে ভাই ওরকম ভাবে হয় না ইউ নো এভরিথিং দেন ইউ আর
Give the copy.
very nice I will know don't show to your temper Mr.
Listen, it is the first matter in the morning.
No, I am why he is showing this
No, he wants
soft
to know what you are relying
I am
on.
saying I am sending him to soft coffee.
Whatever, let him know at least.
Yes, I am sending him to soft coffee.
Yes.
Even then he is shouting.
Yes.
Well, kindly come to first ground number 8.
Which page is it? 181 is something else.
241.
241.
It starts from that
All right,
241.
241.
Kindly similar.
Ground number 8.
Whether the Honorable Division Bench of the Honorable High Court of Calcutta have failed to consider that in gazetted notification the Schedule 2, 10 marks will be given for prior teacher. This point is newly added and with intention to accommodate those who are working as a contractual teacher in a private instance. So the benefit will not be given only to the untainted teachers. They have lost their jobs due to the fault of the school service as well as the state government. So by adding this clause, the state government are going to recruit the contractual teacher by allotting 10 marks extra. Next, my lord, ground 15. Page number 244.
Yes.
Whether the Honorable Division Bench of the Honorable High Court at Calcutta have failed to consider that this Rule 2025 is a perfect legitimate means for arbitrary whimsical action of authority. The authority cannot create any special class of people to give any extra benefit by way of experience marks. This rule has not a hint of reasonableness. The protection provided under Article 14 of the Constitution of Indian Constitution is also denied by this notification date 29th May 2000. That is the said rules of 2025 and the notification date 30th May 2030. The administrative further the authority arbitrarily whimsically can make the rule 2000 decide that the selections process will be held by following the 2020 thereby failing to provide equality before the law and equal protection of the law, and therefore notification so and so said rule that the advertisement are unconstitutional, ultra-vires and so on. And Miller kindly take in
one thing.
ground 7 also.
1 minute. These grounds are challenging which order of the.
That's the order of division being presided by Justice Somensen.
All right.
Miller, kindly come to Miller once. I'm sorry.
Page 194 is the order possibly?
Page 194.
In terms of page 196.
No, main order.
196.
Miller, main order is 196. Mr. Bhattacharya's argument.
196.
Miller, and you see, Mr. kindly come to 199. Paragraph 6.
Yes.
Mr. Bhattacharya has submitted that the finding, observation, and directions contained in the aforesaid orders are to be strictly followed. The notification of the WBCSC does dated 30th 2025 insofar as its attempts to fill up further vacancies would be in clear violation of the aforesaid directions and are not permissible. Mr. Bhattacharya further submission there has not been significant change in the rules of 2000 which would render the present applicable. It is submitted that the prior teaching experience for 10 years was not an eligibility criteria in the earlier. Moreover, the percentage so and so 48 with a clear and manifest intention to make the present appellants disqualified and otherwise qualified candidates in terms of the orders mentioned above would now be not allowed to participate under the rules of 2000. The present notification and rules are intended to and tailored to exclude the candidates qualified to participate under the recruitment rules of 2016. Moreover, all the appellants, or most of them, have become overaged by the time limit and disqualified under the state rules of. All the appellants are victims of circumstance unless the state rules of 2005 is set aside and the present appellant would lose valuable rights and have accrued in their favor under the recruitment process. Mr. Bhattacharya has strenuously argued that neither the order of the Honorable Division Bench nor to several orders of the Honorable Supreme Court has limited the participation to the candidates appointed in the state selection process of 2016 in the process. It is submitted that the word used are candidates in paragraph 45 and 5 of the judgment which would include the candidates participating in the selection.
This is not relating to 10 marks.
No, not relating to 10 marks. Now, Miller, kindly come to the judgment relevant portion. Which is finding, kindly come to finding.
Internal page 22.
Internal page 22.
But my lady, may please see
this was placed.
Huh?
This was placed.
Miller, kindly see page paragraph 18 also.
State's reply, page 205. It pertains to prior teaching specifically.
It is submitted that when the expert committee has formulated the guidelines relating to recruitment of teachers, unless it is established such change of policy would be in clear violation of statute or constitutional provision or arbitrary decision of the authorities are to be respected. It is submitted that the rules relating to prior teaching experience was one of the criteria in the notification dated 2026 and it has been reinstated in the recruitment rules of 2002 to ensure quality teachers in teaching standard. Whether the recruitment policy of 2016 is better than the recruitment 2025 is not a ground for declaring any of the rules as ultra-vires or to be interpreted as one. So, this is a submission. Now, kindly come to finding
19 and 20.
19. Now, in so far as the variation in marks criteria is concerned, Mr. Advocate General submitted that NCT is the expert body to fix up the criteria for teachers' eligibility. In our country, revision is requirement in make marks pursuant to NCT guide. But what I am submitting, this argument has been made. Then, now, my lord, that's the argument. Now, my lord, kindly come to submission. Come to relevant portion of paragraph. I'm just showing you relevant portion 24. Mr. Bandopadhyay has justified the awarding of 10 marks for prior teaching experience on the ground that it is also extended to the teachers who have taught in schools under Kendriya Vidyalaya Sangathan, Navodaya Vidyalaya Samiti, State Council of Education Research and Training West Bengal, and other government-sponsored schools. Marks for prior teaching have been provided with a view to appointing experienced teachers who will be able to teach students in the regard he has relied upon the decision of the Honorable Supreme Court, so and so. This is an intelligibly differential between the unsuccessful candidates and in-service teachers, which is the writ petition have sought to well from the Honorable Court in this proceeding. Then other arguments, this is not relevant now for the timing. Now, my lord, kindly come to paragraph 34. The policy. The awarding of 10 marks is an weightage to be given on the basis of experience, and if it is only expected that in a selection process of the nature and kind, all the candidates are required to undergo the rigorous of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. The object is to select and appoint experienced teacher, as rightly pointed out by the learned advocate general, Mr. Bandyopadhyay. So as far appearing on behalf of the commission, the appellant are not coming within the purview of the categories in whose favor benefit and conscience have been extended in paragraph 49 of the judgments of the honorable. They are not the candidates selected in the 2016 recruitment process. In the meantime, they have not also applied for service in any educational institution. It shall be the duty and responsibility of the state to ensure quality education, and the eligibility criteria should be framed keeping in mind the interest of the students. If we accepted the submission of Vikas Ranjan Bhattacharya, learned senior for the selection for the same subject, teacher two different eligibility criteria has to be applied. The eligibility criteria in the selection process of 2016 is different from the recruitment process of 2020. The rules are more stringent and student-centric. The revision in the eligibility criteria is in accordance and consequence with the NCT guidelines. NCT is an expert body to fix the criteria. NCT is the statutory regulator for teacher education in exercise of powers, so and so. It makes regulations specifying wrongs, so and so. The Commission has followed the state guidelines prepared and recommended by an expert body. There cannot be any compromise on the standard prescribed by the NCT. Education system will fail if we compromise on inequality, so and so. All recruitment rules must present eligibility criteria. This is then. Will not kindly come to next page. Page 219. This
paragraph they mention no rule challenge.
will maybe teacher for the this will yes line 4 kindly see the prior teaching experience is an important factor as experienced teacher may impart education for effectively and efficiently. The recruitment rules 2025 has not been challenged by any of the applicants. The delay in the fresh recruitment is due to the pending litigation, and when the opportunity for employment is open by always open for the authority to decide the eligibility and other criteria in the academic interest. And for the benefit of this, we accept the submission on behalf of the state respondent that there was no specific direction in the order of the Honorable Supreme Court by which the state is obliged only to fill up the declared vacancies on first SS1. So this is going. Now come to paragraph 35. First, if the government felt, if the government felt that the experience gained by the candidate is relevant, the court cannot take a different view in judicial review. Similarly, percentage, any age limit for a given post and also deciding the extent to which an election can be given to the state age limit are essentially matters of policy. The criteria laid down by the recruitment process 2000 was intended to select the best of the candidates. The right to education guaranteed in terms of Article 21 clearly envisaged quality education being imparted onto the children, which in turn would signify that the teacher must be meritorious and the best of the lot. Any process which applied equally to all the candidates and was designed to garner the best talent cannot be called in arbitrary. But although at the top of the judgment, although it has been said by Mr. Bhattacharya that no, we are not challenging this rule, but at the time of argument, he has dealt with all that. He made all these arguments. And kindly take the judgment and order of Justice Shogato Bhattacharya. That is very important, Miller. Point is this, Miller, point has been taken. Thereafter, if any challenge has been made, argued in one court, then the higher court, some points should be, that is the case of abundance. That is not the case that point has not. Kindly take, Miller, Justice Shogato Bhattacharya's judgment, page 128. Will kindly come to para 5.
Page 131.
131, right. Right. Challenge has been, my lord, challenge has been thrown to West Bengal School Service of Selection for appointment of the post of assistant teachers for upper primary level of classes so and so rules, and recruitment notification dated 30 issued by the secretary with so and so. Mr. Bharjal Anastina representing some of the petitions submitted in terms of judgment. Then para 5, you'll also see it is clear the challenge, whole challenge of the rules was there. Then kindly come to me, Lord, paragraph 10. Paragraph 10, yes. It is submitted, yes. Another limb of submission made by Mr. Bhattacharya is against some of the provisions contained in the said rule of 2025. It is submitted that recruiting authority ought not to have altered the provisions relating to fixation of 50% marks instead of 45 marks, which is in earlier recruitment rules in graduation. Just pause for a moment here. Here, the Honorable Supreme Court has safeguarded that this 50%, that only 45% would be there. There was an interim order, which is in earlier to be alleged as eligible. According to petitioner, distribution of mark, that is 10 for prior teaching experience, 10 for interview, and 10 for lecture demonstration, or not to have been provided, which would given the recruitment authority and the interview board unbridled power to allot marks indiscriminately. Therefore, this point was taken before the learned single judge. Although Mr. Bhattacharya started before the division, no, we are not. But here, he has made the submission. And before the division bench, while making his submission, he has made argument why the 10% marks are arbitrary. Therefore, his submission that no, I am not challenging, that is not reflected ultimately from the judgment. Now, against this, all this Supreme Court, SLP, etc. filed. Now, Obijit Sadhu Khan, which I have shown to your Lordship, he was not a party here in this matter. Obijit Sadhu Khan preferred the SLP directly against this judgment, against both this judgment. There, I have pointed out to your Lordships regarding the points regarding 10 selection. May I just, she is also here, she knows, she is here, I am also there. I just informed you, the Supreme Court has said that we will examine all the issues. Matter has been kept on 24th and 26th. Therefore, that kindly come to page 263 of the compilation. Kindly see status. But order was also passed. Yes, note a matter will come up on 26th. Date has been given.
The petition in our compilation. I'll show my date.
Therefore, I have at the threshold I have said so that your Lordships can now you decide whether your Lordships will decide the matter, or otherwise I am ready for making all my arguments here.
Number 9, the point that I have taken was that your Lordship has gone through all the orders, when these 10 marks are to be given, and whether I have not challenged the rule, and whether even if the rule is taken to be valid, whether 2016 candidates whose appointment has been declared null and void would be getting any marks. And for that, my lord, only one judgment of the Supreme Court in
No, এখন তো মুভিটা আসছে না।
like to place. My lord, Lordship,
we'll go one by one.
Yes, we'd like to finish our submission this side and then go to that.
And if your Lordships wishes to hear the main matter, I have no objection. But I just tell you, Lordships, I am making a submission.
But then more or less, whatever your submission is, you have made, that this is all right, it can be done. Division bench's order is in your support. This is more or less your argument.
And another one submission, Millard, that your Lordships, the law is very settled. That is the binding precedent of the division bench.
Yes.
And very recently, Justice Bagchi has delivered a judgment regarding the binding precedent.
If you want to rely, you please.
No, and if you're this is the preliminary point. I have taken this, but if your Lordship wishes to hear on merit of the matter, I have to make this argument. Kindly give this judgment. 2025. Bikramnath ta down. Justice Bagchi ta down, anke bhai. Is it in this? Is it in the? Yes. কোথায় আমাদের কম্পাইলেশনটা মানে take our compilation.
Yes, your compilation is here.
No, judgments, all judgments are not here. I'm sorry.
Again, judgment, such a big compilation, and
there are so many judgments. Just on the basic points, Miller. 2025 SCC on line SC 970 paragraph 17. Kindly see.
Paragraph 17?
Paragraph 17 of the 2025
Yes, SCC.
SCC online. Kindly let me read. Number of judgments are there, but I have just shown this. And latest day before yesterday, one judgment has been delivered by Justice Vikramath. Recently, it is argued that there are cases or counter cases and proceedings against parents-in-law have been quashed by the coordinator. Nothing the parents-in-law are septuagenarian, and there is no whisper in the FIR that they participated in the assault proceeding against them was quashed. Uncontroverted allegation the FIR charge 6. He stated on the same footing putting when the other in-laws, brother-in-law, sister-in-law against whom the proceeding was not quashed in criminal petition, though the order refusing to quash the proceeding against some of them in-laws was purposely impugned order. It was incumbent of the judge, while quashing the proceeding against the respondent husband, to refer to the earlier decision of the coordinate bench and distinguish the reason therein to arrive at a different conclusion. Failure to do so infracts judicial propriety and discipline. Consistency in judicial outcomes is the hallmark of a responsible judiciary. An inconsistent decision coming out from different benches shake public trust and reduce litigation to a punter's game. It gives rise to various insidious sharp practice like forum shopping, spoiling the clear stream of justice. Impugn order suffers from the vice of judicial caprice and arbitrariness and is liable to be set aside and also on this court. And very written, my lord, there is judgment of 2025 SCC on line Supreme Court 2366, paragraph 1 to 14, 1 to 4, the Kobe judgment delivery. This is 7 November judgment.
Paragraphs 1 to 4.
1 to 4.
Yes.
The judiciary draws its strength from discipline and not domination. The Constitution of India creates courts of record that are independent in their spheres and yet binds them together through a coherent hierarchy. The High Court in India possesses a wide jurisdiction, but the Supreme Court of India remains the final interpreter of law. Article 141 of the Constitution of India declares a law laid down by this court binds every court in the country. Further, Article 144 of the obliges all authorities, civil and judicial, to act in aid of the court. These are not ceremonial recitals. They are the structural guarantees that convert disperse adjudication into a single system that speaks with one voice and commands public confidence. Appellant's jurisdiction exists to correct errors and to settle the law so that like cases receive like outcome. When a superior court reverses, modifies, or renders, the court below must give full and faithful effect to that disposition. The authority to decide and appeal carries the authority to require compliance for without obedience. The hierarchy would become an empty form. Resistance or evasion does not merely deserve a party. Before the court, it erodes predictability, multiplies litigation, and weaker faith in the rules of law. The maximum interest replicate unseat finds litium, which literally means that it is the public interest that litigation should come to an end, reminds us that the society has an interest in achieving finality, and finality from the apex court in the guise that holds the nationwide system of justice. Judicial discipline is the ethic that turns hierarchy into harmony. It requires courtesy, restraint, and obedience to binding precedent, even where a judge is personally unpersuaded. The lawful course is to apply the precedent and, if needed, record reasons for inviting a larger bench to reconsider it. The unlawful and unjust course is to distinguish in name of while disregarding in substance or to recast issues in order to sidestep a rule that binds. Stare decisions are not quiet movers, which means to stand by decision and not to disturb the settled matters, is not a slogan but a safeguard of equality before the law. Judges do not sit to settle scores. The gavel is an instrument of reason and not a weapon of reprisal. A vindictive stance is incompatible with the oath to uphold the Constitution and the law. Judges across our country must remember that collegiality is the companion virtue of the independence, and that a reversal on appeal is not a personal affront but the ordinary operation of a constitutional hierarchy that corrects error and settles law. Respect for the senior jurisdiction is not subservience. It is an acknowledgement that all courts pursue common enterprises is to do justice according to law. An appellate court reviews and, where necessary, sets rights the decision of the lower court with restrained and measured language, and the courts below reciprocate through prompt, reasoned, and transparent compliance. Court speaks through reasons and reasons that align with the binding authority, preserve both the legality and legitimacy of the judiciary. Article 144 of the Constitution makes obedience a custodial duty and not a matter of personal preference. A judgment that attempts to resist binding authority, undermine the unity of law, burden litigation which avoidable expense and delay, and invites the perception that outcomes depend on the identity of the judges. In a constitutional judiciary, it is the law as declared that brings the conversation to a close. We restate the simple duty of the courts, apply precedent as it stands, and give effect to the appellant's direction as they are framed. In that discipline lies the confidence of litigants and the credibility of the courts. This is a preliminary point which I have taken, that otherwise, if you lordship feel to go into decide the matter, then I will address on merit.
Take it on merits. What further? You've made 11.
Oh no, merit I have to make so many submissions.
What submission? Because all your submission is possibly recorded in the judgment of the Honorable Division Bench. It's a big detailed judgment with the precedents that you've relied upon.
Yes, that's correct. That's correct. But that's a
advance arguments on maintainability. Before my ladies, I'd like to supplement.
yes,
Mr. Banerjee,
yes.
you mentioned
No, I have
maintainability.
I have been told by my juniors that the observation, reasonable classification, obiter dicta, etc. That if your lordship wishes similar, I can address that also.
No, in that case, I have to hear the petitioners first.
Well, that's naturally. Otherwise, judgment which I have been telling you, my simple submission is this.
The matter is pending before the Honorable
Supreme Court.
Stay their hands for the time being.
Let us see.
Exactly the same line of Mr. Bandopadhyay, because I will not be repeating even with the same sentence. I am completely adopting it. Only I shall be saying two things. Thing number one, there is a 2025 judgment of the Honorable Supreme Court, which Snehal, 2025 SCC online SC 2325, paragraph 10. Justice Gawai's judgment. This is exactly what Mr. Bandopadhyay has submitted, and I am also adopting it. So, just the language. Not in paragraph 10.
Yes.
We are deeply perturbed by the approach of Said Sri Rahul as well as the High Court of Uttarakhand when the Said Sri Rahul was continuously, kindly mark this word, because this whole thing started for a long time, continuously following the proceedings before this, that is Supreme Court, and was aware about the oral observations and the orders. If I can just have a little pause. Last night, I myself saw the entire video of what exactly was submissions on the part of the petitioners for the SLP, and I was completely convinced. All these were there. The Honorable Supreme Court had something specific in mind, which cannot be given to everyone. Like, what is the meaning of tainted? What is the meaning of untainted? What in the context of a list? All aspects. Why the freshers? They were not given relaxations. All were argument made and negated. Now, if I continue. And the orders passed by this court, nothing prevented him from intervening in these proceedings if he was of the view that any of the orders passed by this court or any of the observations made by this court prejudiced him. However, in the teeth of the sanction which was granted during the pendency of the proceedings before this court, approaching the High Court to challenge an order virtually amounts to this interference in the present proceedings. The High Court, no doubt, is a constitutional court and not inferior to this court. However, in the judicial matters, when this court is seized of the matter, now this is the words, seized of the matter, it is expected of the High Court to keep the hands away. Well, that's the reason I said it's not that Lordship doesn't have power. There is something, we use the word propriety. When the Honorable Supreme Court is seized of the matter, it despite of the fact that Lordships can, I'm not saying taking an extreme view, cannot at all, can, if Lordship goes into that micro analysis of it, most likely, if there are two options, both options being available, Lordships might choose the options of not interfering because of the simple reason that the Honorable Supreme Court is in seized of the matter. So this is clearly on this. Now, just one more point and I would not say anything. My lord, kindly, my lord, visualize a very fundamental thing. When a legislation or a rule is challenged, two things are different. One, what is challenged and what are the bases of the challenge. What is challenged is a fixed rule. Basis can be X, Y, Z, etc. In the prayer in the writ petition, there was a specific challenge so far as this rule is concerned. It is possible that, my lord, there is always an innovative argument. Kindly visualize that once the rule which has in the prayer was challenged and it was not granted, rule was not declared to be ultra vires, and the matter ultimately went before the Honorable Division Bench and the Honorable Supreme Court, just because of one sentence, well, in fact, factually, that's an incorrect statement. That rule was not challenged before the division. That's not factually correct, because I have seen the prayer. In the prayer, specifically, rule was challenged. And that is also corroborated with Mr. Bandyopadhyay has referred that the Honorable Justice Shogato Bhattacharya also recorded regarding specific point of prior teaching experience. So all I say, it is possible that there can be a new XYZ.
Anyway, your submission is also to stay the hands.
Yes.
My lady, may I just address you? I've just capsulated all of this in a short note, 5 pages. My lady will have everything. And this is the compilation that goes with it. Please pass this on. This is the compilation that goes with it.
You are appearing for one of
I
the
appear
interveners.
in 4 cans. We prepared a list.
Interveners.
Yeah,
All right.
interveners. Can 4, can 1, and then in writ petition 24899, can 4 and can 1. So
All
4
right.
sets of interveners. We are obviously here also on that the merits have been argued, but simply on maintainability. I'll just take you to the first page. Now, my friend Mr. Banerjee very eloquently argued this principle of stare decisis, which my lady is also bound by. And my lady, may I just start by saying this is my first physical appearance in my lady's court. It's an honor to be here.
Yes.
Very
Thank
happy
you.
to be here. Now, my lady, may please go to page 2 of my submissions. Just page 2. This is para 9. This is the petition where the Supreme Court has issued notice on. This is the petition where the Supreme Court, this is Avijat Sadukan versus State of Bengal. Notice has been issued by the Supreme Court on 25/8/2025. Relevant grounds of challenge are at questions of law para, and we can look at those pages. And if you just see the pages of this, the compilation, we want to make this very simple and convenient, my lady. My lady may eventually agree or disagree, but we want to make it easy. So please see page 415 of the compilation that I've just submitted, page 415. This is the petition that was filed, the SLP that was filed in the Supreme Court, on which Justice Sanjay Kumar and Arvind Kumar issue notice. And this is the bench of the Supreme Court which has been seized of these matters pertaining to recruitment of assistant teachers. Now please see page 415. My lady has the compilation. Paragraph 8.
Are you all aware of this?
Paragraph 8.
I don't want to waste the time of court.
Yes.
Can I just take you to this? Yeah, let me just finish.
Then get exhausted.
No, you tell me one thing. If the issue is pending there and you can raise all issues over there, let the court stay its hand for the
Yes,
time.
yes, my lady. Yes.
No such issue of constitutional violence is pending. Let them
This is
have
wrong.
it up.
May I just finish?
What
Let me just...
SLP means? No, I don't have to teach anybody what
Yes,
SLP
yes. Yes, it's all
But
right.
the SLP not really arose from the fundamental order passed by the High Court, where High Court says that the violence
Whether 2016 rule will apply or the 2025 rule will apply.
That is
This
different.
is the
That
challenge.
in my
The virus of 10 marks. That is what is pending before the Supreme Court, amongst 12 other questions of law.
Yes.
No, but here we have challenged the constitutionality of 2025 rule.
Yes.
That was challenged.
Which was never before the court. The division bench was very categorical, saying the rules are not challenged. The division bench interpreted on the strength of the rules being valid. Now I am more on fundamental. I know they are scared of going
on
into
the
issue.
strength of the rule being valid means the 2025 rules is valid.
Yes, this is the issue now. I am urging, I am an independent petitioner. That council might be saying, but council.
No, I understand. But if the issue is decided, then there is no point in deciding it all over again. It cannot be done.
Issue, Milord, is not pending. The Supreme Court, with deepest of respect of my little experience, will not go beyond the fundamental order passed by the court. Therefore, here, the raising the issue is really simply trying to avoid the court, nothing else.
My lords, my lady may please see page 414. These are the questions of law that are pending before the Supreme Court. Please see that the Calcutta High Court has failed to consider the entire recruitment rule of 2016, and therefore the second state level selection test 2025 is completely changed. This is page 415. Please see the bottom of page 415. Question 8. Whether the Honorable Division Bench of the Honorable High Court of
read
Calcutta,
out just now, Mr.
yes,
Bhatt,
has
read
failed
out
to. This is the petition that is pending at the Supreme Court, which the Supreme Court has issued notice on. So when the apex court is seized of the matter, including any and all questions that are being raised by my friends through a backdoor entry in violation of stare decisis, judicial discipline, and hierarchy of courts.
What is this?
I don't know what this is. Please stop all this. Please stop all this.
A minute.
Please.
Who are not the advocates will please leave the courtroom, because the entire proceeding is live streamed and anybody can see. Please leave the courtroom.
Yes.
Now, may I keep reading, my lady?
Please leave the courtroom. This is not this way how the Calcutta High Court functions. Apart from advocates, please leave the courtroom. What is happening? Right, will please leave. Whoever's clients are there, please leave.
May I keep reading, my lady? Whether the Honorable Division Bench of the Honorable High Court, bottom of page 415, has failed to consider that in Gazetted Notification Schedule 2, 10 marks will be given for prior. Yes, now may please see 15, 418. Can I finish, Mr. Bhattacharjee? Is this the way we argue? Let me finish my arguments, then you please. Now please see 418.
What you want to show?
That this is a calibrated attempt to disturb the functioning of this court. But I am not. This is the Facebook posting by one of the aspirants who want to get 10 marks, not being qualified for this purpose. They are posted. কাল সকালে কোর্ট চত্বরে সকাল সকাল যেন ভিড় করে থাকে। I am not mentioning the name of the judge. ঢোকার সময় যেন দেখতে পায় ডাল মে কালা হয়।
No, this is
বলবে আমাদের কেস আছে সেই জন্য এসেছি চাকরিহারা শিক্ষক শিক্ষিকা।
Please leave. The doors are quite wide. You all can leave out.
How, Mr. Bhattacharya, if you place this, we can place so many of your junior statements.
This is not the way it's done. This is not the way it's done.
Whatever they will be placing. Sir, this copy has not been done despite your lordship's direction. They had agreed that they will
affidavits of service are complete.
Any document.
Soon as they cannot go out, then the court has to stop.
Advocate, nobody should be allowed to enter. These matters.
Since the proceedings are live streamed, everybody can see it. What is the use of law?
Absolutely.
It's absolutely no use. And if they think that they're going to put pressure on the court, I'm sure the bar is there to save the bench.
What I am submitting from the next day, whenever these types of matters, no.
Yes, outsiders.
No litigants. My lady, may I keep reading? Page 418, ground 15. Ground 15 of the petition filed in the Supreme Court. Whether the Honorable Division Bench of the Honorable High Court at Calcutta has failed to consider that this Rule 2025 is a perfect legitimate means for arbitrary whimsical action of the authorities. The authority cannot create any special class of people to give extra benefits by way of experience marks. This rule has not a hint of reasonableness. This is the ground. The protection provided under 14 of the Indian Constitution is also denied by this notification dated 29/5. This is exactly what is challenged before my lady. Now please see, my lady. Please
1 minute. You are reading from Abhijit Sadhuka, isn't it?
Yes, my lady.
Are the petitioners aware Abhijit Sadhuka's petition?
No.
Please take down note.
They are aware about Orunima Pal.
Orunima Pal.
Orunima Pal as well, Milord, is there.
Abhijit Sadhuka.
No, Milord, we have. Milord, Abhijit Sadhukan's copy was served on last Saturday.
No,
Mr. Sami.
They do not know. They are not part.
May not be.
We've given a copy of everything. All the arguments, judgments, rules, everything.
Mr. Sami, Mr. Dasgupta.
Abhijit Sadhukan's SLP, Milord,
This is what is read.
Mr. Bandopadaya's copy.
And they are all Orunima Pal. If we are aware of Orunima Pal, Milord, I'll show that every point was taken.
All right. Yes. Now, may I just take you to page 431, which is the Supreme.
Right now, it is Abhijit Sadhuka's SLP grounds that are being placed.
Page 431, Supreme Court issuing notice on this petition. The grounds which I read.
All right.
Please see, it's a detailed order. Justice Sanjay Kumar issues notice. It's a detailed order. Now, please see. Can I just take you back to my note, page 3? Again on maintainability.
1 minute, 432.
431, my lady. It starts.
Yes.
25A.
Yes, next page. I see notice have been issued.
And tagged with SLP diary number titled Bibek Parya.
And the court directed that in the meanwhile, all selected and appointed untainted candidates, selected and appointed, who were permitted to continue shall be allowed to participate in the fresh selection.
Yes.
Without insisting upon complying with 50%.
Yes, my lady. Because the Supreme Court had, on this 50% criterion, had protected it because of the nature of this recruitment process. And you'll see at the bottom of that same para, classes 9 to 10, classes 11 to 12, rules 2025. It is exactly what is pending before my lady. Exactly. Now, please see. May I just take you to page 3 of my submission notes? On maintainability again. Page 3. We have now, Mr. Banerjee has now gone through stare decisis. We have now shown to my lady that exactly the same questions, the same issues are pending before the Supreme Court where notice has been issued. Now the third point, the law on this. The law. Why this is not maintainable in law as well. Top of page 3. Qualifications for appointment. My lady has this. Top of page 3.
Yes.
Qualifications for appointment to a post are within the exclusive discretion of the employer. So these 2025 rules, my lady, now the Supreme Court has settled the law in Maharashtra public servants. Now prior experience, please see middle of this page. Prior experience marks in teaching, middle of the page of same page 3, were upheld by the Supreme Court in Allahabad University versus Gitanjali Tiwari. This is what I told my lady virtually when I was appearing, paragraph 16. The practice of according marks for prior experience in a recruitment process is not unique to this recruitment process.
Yes.
UGC regulations, my lady, this is all India regulations on minimum qualifications, has exactly the same rule. You will find exactly this rule in many states vis-a-vis recruitment of teaching, and they are all sustained on the basis of these two cases of the Supreme Court. That the employer, in this case the state, gets to decide within its executive and legislative discretion that we require this prior expertise. A class 9 student would benefit greatly by having a teacher who's got 2-3 years experience as opposed to having a fresher. Now please see page 4. I prepared this note just so that I won't take much time of my ladies. Please see page 4.
Only one thing. Case Lordship feels that Lordship is not going to interfere. It may not be proper to say anything on it. That I feel.
No, nothing on merits.
No, nothing on merits.
Right
Nothing on
now,
merits.
I'm thinking of whether to entertain.
Yes,
or to
maintainability.
entertain.
Maintainability.
No.
Yes. No, this is on.
Not on merits. Not on
My
merits.
friend may let me argue. I didn't interrupt you. So please see paragraph 14, page 3. Just on maintainability. Paragraph 14, page 3 of my submission note.
Yes.
Please see what the Supreme Court says on qualifications. What is before my lady is the ability of an employer, the state, to prescribe qualifications. Can a court traverse that? Please see what the Supreme Court says. Maharashtra Public
Not
Service.
on merits, please. Not on
No,
merits.
my lady, this is not on merits. This is on the principle of law. Employer may prescribe additional or describe.
Right now, what is going through the mind of the court is whether to hear y'all at this stage or should I wait till the 24th or the 26th?
Please wait, my lady, while the Supreme Court is seized
What
of this.
is, going through the mind of the court?
Yes, and this is a bench of the Supreme Court because I've argued it from day one before Justice Sanjeev Khanna. This is a bench of the Supreme Court that has been seized of this matter from when Chief Justice Sanjeev Khanna first set aside the recruitment. Now Justice Kumar is hearing all these petitions from Calcutta on recruitment specifically.
Mr. Bhattacharya.
May I just hand over the note that you
Again, note.
That small note your lordship wanted on the other day.
One has come. This is the second one.
I have not.
Please don't. Yes, the slimmest.
No, I have not given note. I have given the documents and the judgment.
This one is also the document.
Not note.
See the number of candidates involved. For this, the documents are so.
I have set out the press that has been made.
Two copies. Two copies.
You don't allow.
2 copies have come.
My lady will take
Give
one
the
copy.
copy first, then I will come.
Share my lady's copies.
You are also for one of the interveners?
Yes, sir. In can number 5 and item number.
Whatever.
Supporting us. Okay, then I thought it that you are Mr.
Couldn't understand whether supporting or opposing.
He's support. My lord, those supporting are genuinely more jovial, my lady. We are optimistic. Those opposing are not so.
I have set out the prayers made below in each and every new petition which has been disposed of. Your lordship will find in only Mapas, there was a specific prayer challenging the rules. My lord?
No.
I don't have to, I have authorities that in a separate petition, below, a petitioner can challenge even the order passed in a similar petition by the other court. Kindly takes up what is the foundation, order of Honorable Justice Shomen Sen in Math 1017. All SLPs arose from this. Well, let us go to the basics.
Will it be very difficult, Mr. Bhattacharya, if when the matter is taken up by the court on the 24th or the 26th, the Supreme Court, you'll get an order, one-line order, that this can be urged before this bench? The court will be open to hear it.
Lord,
Why transgress?
I am not before the Supreme Court. I am a petitioner.
Independent.
No, not this party. That is different. That is different. I understand.
Counsel.
No, as a counsel, it's all right.
I have argued on the same
Yes.
positions.
Well, right. It's not that. It is not that. But there are many who are parties over there. If one-line order can be obtained from the Supreme Court that this individual challenge to the rule can be entertained by the High Court, the court is open to it. This will settle issues.
May I answer? Lord, you kindly excuse my impertinence.
No, it's all right.
But the question is, the Supreme Court will mock at me that having not gone through the order appealed from, what is the order? I just placed the order. Kindly takes up the division.
The order has been placed.
No, they have not.
You have
the issue. I am sure the order has not been placed in the context. Kindly come to me, Lord. The kindly takes up the judgment of the division bench. The present appeal, paragraph 2. We have seen in the country, how the tainted peoples always was take advantage of the situation. And the law is well settled, but they cannot be allowed to participate and get the marks. The present appeal, I am talking everything on authority. I am not talking on my own wit.
Compilation dilo page number 371.
The present appeal, paragraph 2.
Page number 371 of Abhijit Sadhaka. 371. Page number 3.
Division bench judge.
Orunima 371. Page number 371.
This appeal, the just honorable division was considering the present appeal is directed against a portion of the impugned order whereby the contention of the appellant that the recruitment process initiated in 2025 on the basis of the said rules of 2025 could not be made applicable to the present appellants as they are to be considered under the recruitment rules of 2016 was rejected by these orders.
What I could understand from the order of the Honorable Division Bench is that the broad question was considered by the court whether 2016 rules will follow or the 2025 rules. Nothing individual. This is what I could understand.
And you have correctly understood that is the scope of the division judgment.
Now, at the time of deciding this, the court has gone into the finer points, whether 50% is proper, whether 10 marks is proper, and whether the authority can fix up the eligibility criteria and all these things, and the court has passed order. But I have seen the issue before the court was something different. This is what this is what came to me.
And court really said that these issues are left with the executives. Court cannot interfere.
Right.
Now, my point is here that these rules will not violate the constitutional provision. If I can satisfy, otherwise, I am out.
Right. So I will prefer waiting till the 24th or the 26th rather. Let us see what happens because the issue is pending. Whatever order will be passed by this court will always abide by. The steps taken by the authority will abide. That is the interim order in one of the matters.
My lord would be pleased to then record that while the matter has been considered for constitutional validity, the point is taken that this constitutional validity is being considered by the
Supreme Court. I'll record that in the order.
On that ground.
Yes. On that ground only.
This is one point. Another petitioners I am representing, where we not taking the rules 2025 as it is. Even then, at what stage the
10 marks can be awarded? I'll come to that later on. Let me record it.
Item number 14.
That is separate. That is separate. No. I'm not saying. This is whatever.
No.
That was
whatever. See, a client, when a litigant comes before the court, the litigant prays for the moon. But the court doesn't consider that.
The court says the recruitment rules of 2020 has not been challenged.
Right. So please come.
Please come. Serial number 14. This is issued completely different because 9, 10, the untainted teacher is eligible to get marks for the 11, 12.
3. This is item 3.
Yes.
This is item 3. Just wait.
Interview published. Subject matter of outcome of this petition. Subject matter of outcome. 3, 4. Item number follow.
সেদিন আমি থাকবি চাকরি দরকার
5,000 লোককে চাকরি দিয়েছি
The issue as to whether 10 marks can be allocated for prior teaching experience in the
open selection, direct recruitment.
2025 rules. Likhen into West Bengal School Service Commission selection for appointment to the post of assistant teachers for upper primary level of classes except work education and physical education. Classes 9 and 10 and classes 11 and 12 rules 2025 are impugned herein. Paragraph. Learned counsels representing the commission, the interveners, and the state respondents submits that the said issue is pending consideration before the Honorable Supreme Court and the matters are due to be taken up for consideration by the Honorable Court on the 24th and 26th of November 2025. Stop. Next. Though the aforesaid submission of the respondents has been opposed by the learned counsel representing the writ petitioner, but as several grounds of the special leave petition have been placed before this court, this court is not inclined to adjudicate the issue at this stage. Stop. Hearing of the writ petition stands adjourned till 28th November 2025. Stop. Parties are directed to produce the updated orders of the Supreme Court on the adjourned date. Compilation filed by the West Bengal Central State Service Commission, School Service Commission, the interveners in court today be written with the records.
One thing that has probably gone down, that the court was invited to decide the constitutional violations of the 25 rules. That is not pending with the Supreme Court.
That we would also record this rule was challenged before the
that record from the order.
Is there in the order. Why record all these things? যেখানে বললাম না, it is not challenged. যেখানে বললাম opposes the submission, ওখানে লিখবেন the constitutional validity of the 2025 rules have not been challenged.
Yes. Now the parties may get a clarification so that you see.
I am not mentioning. If you can get it done, fine.
Very well.
This is, you have said.
No.
This is item 3.
In the SLT, how can a variance be challenged?
This is item number 3.
My lord, item number 3, 4, 11, 12 and 13 are similar.
3,
4, 11, 12 and 13.
11, 12 and 13. Same order will go down. Let the petitioners come. No, let the petitioners come. Item 5. Is it the same thing? It is something different. Totally different. All right, please wait. Please wait. Item number 6 is also different.
Private school teacher challenge করে দেন।
Wait. I'll take it up.
রেখে দেবে তাহলে ইন্টারভিউ ইয়ে হবে।
Item 7.
My lord, may I indicate one thing, my lord? Because of that matter, I challenge the 10% if is given to the government school teacher, the same, my lord, benefit ought to given to the others teacher also.
Which one?
That is not in the list, my lord, already filed, my lord. I supply the number, my lord.
Yes.
Otherwise, my lord, the list will publish, my lord, within 1 week, my lord. Matter will become infectious, my lord. It will be kind enough, my lord. Kept any day, my lord. My junior will supply the list.
Item 7.
Item 7 and 8. The issue is whether central government school will get the 10 marks, my lord. 14th, your lordship.
14th.
7 and 8.
But then, objection, yes. The commission doesn't have any objection. Yes, against sanction post.
So that I will satisfy your lordship.
But the 14th. 7 and 8 on the 14th. 7 and 8 on the 14th. Item 9.
My lord, 9 is
certain additional point in 10. 9, Mr. Dashgupta was arguing in the last.
All right. देखिए 9 टा एकटू देखिए. There are many oppositions.
It is 9.
এখানে দুটো পয়েন্ট না কখন দিতে পারবে না পুনরায় কোড পাবে না টেকিং দ্য রুল টু বি ভ্যালিড
That is also there, but it's not appearing in the list. Number.
It is there in a pool. Now it has become a pool.
Now it is there in the pool. On the point of contractual mallet.
Yes, Shishir Dash, item 9.
Wait, with your lordship.
Retreat. Puro, entire file.
হচ্ছে না
This is regarding the stage as to when the marks is to be added.
The interpretation of rules.
But then will we go into this? Let the court decide, Supreme Court, as to whether the 10 marks will be allotted or not. If it is not allotted or allotted, then...
But no, the problem is, Milord, in the meantime, what they are trying to do, they will, Milord, get these, Milord, the favored students again selected, and publish the result, making and shouting that this has become infructuous. Therefore, there are two prongs of attacks. One is constitutionality, it remains. Like even after 10 years, it can be declared otherwise.
Yes.
But here, Milord, assuming that the rules are valid, what should be the interpretation?
What should be the stage? Yes.
But kindly come to Milord. It's not about
No, successful or not is different.
But I am a Milord fresh candidate. Why should
No,
I give
if 22,000 is there,
yes,
then why this 10 marks? When will you add? When will you add? When will you add? Before the interview. Before the interview.
That cannot be done.
It has to be done prior to the declaration of the
Milord,
final merit list.
Milord, and second question would come whether, Milord, these after the Supreme Court judgment, Milord, whether they can be treated as, Milord, qualified teacher.
Qualified teacher.
Because they have the benefit of trying to get the benefit of experience.
Yes.
And after the appointments having declared void, whether they can be said to be qualified teachers.
That means the 10 marks issue comes in. Right?
10
marks.
One is, Milord, 10 marks cannot at all be allotted, irrespective of who is there. Here, Milord, if I take the rules does not permit the tainted in the sense, as the Supreme Court said, whose appointments are declared void by the court. I have a similar judgment in other cases also. Therefore, we are sticking to the interpretation of the rules. And I'm inviting my Lord to deal with this.
No, what will be the, what answer do you want? That the 10 marks can be given to the past, for the past teaching experience, or the stage?
So, two issues are here. First of all, if at all 10 marks can be given, then
at what stage?
At what stage?
Right.
Second, Milord, the 10 marks can be given, Milord, to the teachers having the experience, past experience.
Whether the candidates who participated in the earlier recruitment process will get
be taken as a
eligible.
past experience. That's the point. But kindly come to the rules straightway. Milord,
This is what his submission is.
No, I don't say I could be allotted, but not to the teachers who have no experience in the eye of law. Yes. Well, let me. Whole difficulty, Milord, I am gagged. Let me speak out.
Let this hearing be done one by one.
Let us start. Milord, no. Milord, let me please it. I will be happy to be
Wait.
wrong.
Wait.
I don't claim that I am always right, but let me speak out. Let kindly come to the rules at page 26. Kindly come to 2K. Interview list. In respect of the state level selection test, means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score. Therefore, the determining factor is preliminary merit score. And what is preliminary merit score? That is score from written test and TATE and academic score in the ratio of so and so. Therefore, at this stage of preliminary merit ranking, only thing could be taken note of is the academic score and the TATE, nothing else. Written test, academic score, written test, academic score, and TATE. There's no doubt about it. Then merit list. Merit list is a subsequent stage. In respect of the SLST, means in case of post, a list of candidates prepared category-wise on the basis of merit, which shall mean in addition to what has been stated in Rule 21K, marks obtained in oral interview, lecture demonstration, and prior teaching. Therefore, the prior teaching, lecture demonstration, oral interview comes while preparing final merit list. After the interview is over. If this is the rule, which is very categorically clear, the question of 10 marks, which is prior teaching experience, will come at the stage of preparation of the final merit list, not at the stage of preparation of preliminary merit list. And kindly now turn to the schedule at page 36. Schedule 1 is the academic qualification, including professional qualifications. My lord, will find what is meant by academic qualification, educational qualification. This is for 9, 10, and B for 11, 12, the same thing. Therefore, the academic qualification is defined in Schedule 1. Now, kindly turn to Schedule 2. This is selection to the post of assistant teacher. Now, 9, 10 shall be made on the basis of marks obtained in written examination, educational qualification, and prior teaching experience, oral interview, and lecture demonstration, which in fact resonate with the definition of merit list. There, the academics, educational qualification 10 marks, percentage wise. This is really, Milord, a level playing field. Now, the latest judgment of the Supreme Court, I say, delivered by Justice Dipankar Datta on recruitment, says the level playing field is the sole consideration to comply Article 14-16. Then the prior teaching experience. The prior teaching experience, you wanted to bring under educational qualification, which really contradicts Schedule 1 and also contradicts your main rule. The schedule of a rule cannot go contrary to the main part of the rule. And if you follow this interview list and merit list, then there is no doubt that so-called addition of 10 marks can be offered only at this stage of merit fixation, not at this stage of preliminary screening of interview. Why this is being done? Then I have to go to as I say, this is a malice in law. You are trying to do it because 2016 rules doesn't provide these things. This you are trying to do only to accommodate the persons who have been found to be illegally appointed because of entire corrupt practice. And now again, everybody will say, how do you say this? Kindly come to the judgment of the division bench I am not referring to. Kindly come to the judgment of the Honorable Supreme Court and subsequent clarification by the Supreme Court itself. Let page 130. The delay and latches goes, then kindly come to conclusion, page 131. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates who were appointed must be terminated.
I will request you not to place this now. Let us only decide this issue. At what stage the 10 marks will be given? Interview list or the merit list? Only this. And the other issue that you are raising, whether they will at all be entitled to the 10 marks or not, that I'll keep it open for the time being.
Very well.
Only this portion, this stage.
Well,
Initial or
I will not concede to the observation of court.
Yes, because this will be to some extent touching the other issue that is there before the Supreme Court. Let us see how things proceed.
Now, therefore, so far the at what stage 10 marks can be allotted, below?
Yes, I get it. No, there are some other petitioners. You'll answer in the same go. Academics, you said on the last occasion there is an S which includes a plural. Here it cannot be done.
This one thing.
One.
And second thing I argued, which has not gone down to the order, blood, that interview list my senior has already placed the definition. Merit list definition. Last occasion I had shown to Lordship that this is these marks to be calculated at the time of preparation of merit list is in addition to the marks given in 2K, 1K. Therefore, these marks, total marks is 100. If they give teaching experience at the interview list level, then the total marks would be 110. Because 2K...
Twice you added.
It must be. Otherwise, they are saying, according to the commission, these 10 marks would be given at interview level. Now, kindly
according
read...
to the commission, the preliminary merit list will contain the 10 marks.
No,
because
kindly
that
read,
is in the academics.
Kindly read this in this way, Milad. Means, merit list means, in case of post, a list of candidates prepared category-wise on the basis of merit, which shall mean, in addition to what has been stated in 2K. Therefore, if they give 10 marks of teaching experience in 2K level, then...
Cannot give it in L.
Then it states marks obtained in oral interview, lecture demonstration and teaching experience. Therefore, teaching experience they are in any event giving at the time of merit list, in addition to what is there in 2K. Therefore, this teaching experience cannot be given twice. That's my point. And last question I have submitted that if this 10 marks is given, this rather teaching experience of secondary level is made applicable for senior secondary, then there will be nobody from the freshers who will get chance.
That on the next day. That on the next day.
This is again on not on validity.
No.
That you will show the record.
It will to some extent touch the validity issue because here the those who were there, whether they'll be entitled to get that or not, will be an issue.
16 candidates.
Yes.
As you should please us. I have prepared a supplementary affidavit to bring on record. Sarfaraj. Order of Supreme Court, though you will
Sit.
Only at order of Supreme Court has been next.
Order of the Supreme Court?
Yes.
Which order?
This is again touching to the page 10, only for the purpose of page 10, second paragraph.
17th April.
Page 10, second paragraph.
Yes.
Page 10, second paragraph. Only for this. Only for this. Oh, that's all.
Freshers. They are also freshers.
May I?
Sir, I have heard you on the last occasion.
No,
Nothing
but
more.
after you have to hear me on this.
Yes, yes.
That's I'll at the end I should submit. Let them submit.
No, no, I have heard your submission.
No, not hard on me on this. Now new argument has been made.
No, not a single new point has been raised today. All old ones. Same point.
No, but they have want to hear, do not hear, that's the matter.
Yes, yes, please. Yes.
Hey, Kullan, just a second. Suppose I missed you. In support of my submission, I just rely upon one judgment. Mr. Banerjee will definitely deal with that. 2011 7 SCC. 2011 7 SCC. Page 789.
Is it there in the compilation that has been filed today?
Yes.
আগেকার compilation টা দেখি একটু. Spiral binding.
Page 789.
Spiral binding. What is there in the judgment?
That the schedule of a rule must be in consonance with the rules and statutes.
Well, now that's a separate spiral binding. Give me the citation so that I can take note.
Citation does it?
The Joseph compilation.
1K.
Taken in 2011 7 SCC page 789.
রাখুন
আমাকে শুনতে
নিয়েছে আপনার কথা শুনে নিয়েছে আর নতুন শুনবি
ভুল ভাল শুনেছে
সেই জন্য শুনবে না দেখি এইসব
category wise on the basis of preliminary report that is both from the and of state for transfer in the ratio of transfer by preliminary later given the academic and academic. Then the academic score is within the status. See differences between tests, then state for upper primary and academic. So what is an academic? That has been said by the two academic
page 36. Yes, the schedule.
One is educational qualification 10 marks. Then no rounding up on prior teaching experience 10 marks.
এই তো দেখে আছে আমার এইটাই করতে জানি ওটা তো
Another heading academic. Then come back again, my love. Again to the lot of point then preliminary merit score, written test, state, and academic score. This is for the part of the teacher. Who interviewed it will say who will be interviewed, list of that. Now let's kindly come to L. Merit in respect of the academic means in case of both a list of candidates prepared category wise on the basis of merit, it shall be in addition to what has been stated in 1K. Marks obtained in oral interview, sector and practical and tracking all the activities.
So does it mean the submission is that you will add the prior teaching experience twice?
No.
This is what is mean.
That is a harmonious construction.
Right. You are the commission.
I am not a rule maker. I am the commission.
You are the commission, right? Whether this 10 mark is given at the time of interview or at the time of final merit list, it doesn't bother either the state or the commission.
No, but we are working on that.
You are working, right?
Submission.
Yes.
Implementing rules.
Yes.
I have to implement the rule. Now, this is this is not correct. That academic, it has been more specified. It has been oral interview, lecture, anything. Why is it? See, because academic score in score transfer and merit list means in case of post, a list of connect on the basis of merit. So means in addition to what has been stated in book 8, marks obtained in oral interview.
What does this mean? That means there is a separate mark in 2K, and then with what you get in 2K, you add up oral interview, lecture demonstration, prior teaching experience. This is what is mentioned in the... No, but this is what the state government rule says.
Now your losses kindly come. Let's make an harmonious construction.
Let us make an harmonious construction, and whatever is there in the rule itself. Why will you jump steps? The L. Let us read L. Merit list. Please read once again.
Merit list in respect of the SLST state selection case. In the case of post, a list of candidates to state category. Why? On the basis of merit. We shall mean, in addition to what has been stated in the rule, 2K marks obtained in
Right. So 2K, there is a mark fixed, allotted. With that, you add up oral interview, lecture demonstration, prior teaching experience.
Prior teaching experience already has been taken.
Then why will it be repeated twice?
Redundant.
Ah.
Now, not be now the
Yes.
Definition.
Advocate General state 11(8). See, the Central Commission. Central Commission.
That will mean
an eligible category on the basis of the preliminary merit score as defined in 2K in the basis of 1.2K of final result.
There is nothing mentioned about the prior experience in this 8 that you read out.
No, not here, but I say that 2K and 11 Romani. While interpreting 2K and L, Malad, this court cannot ignore 11 8.
No question of ignoring. Yes. All right.
Everybody. Now, kindly, this is the judgment.
to bullshit. তাহলে কি আর কি আছে ওকে শুনতে চাইছে না ঝামেলা করবো তো
Yes.
Volume 2 SSC 2002 volume 2 SSC T1E. Kindly come to paragraph 11.
What is there, please say?
The interpretation to section 3 as noticed therein offered by the High Court cannot be possible by adopting neither the statute can be read in the manner and fashion available to done by the High Court. Appointment of the competent authority of right now purpose of the act indicate the authority is administrative and neither judicial and proceed. The statutes shall have to be considered in its entire and picking up of one word and from one particular provision, thereby analyzing in a manner contrary statement of objection is neither permissible nor warranted. There are certain fixed canons of construction and interpretation of statutes and the High Court finding as regards the office of the competent authority influence. But this is a principle. Now, another one judgment. But then my submission would be that to this limit, that it has to be read, it will be done, it will be on the basis when the intent is will be prepared.
All right. Yes. Yes.
When we interpret a rule, the first thing is
find that there is no challenge to it. First, if there is a challenge to the rule, then the parameters are completely different. Whether it exceeds the legislative power.
Please do not make this submission. That is not the issue.
Now, today, Milord, your Lordship is invited to look into or adjudicate as to at what stage the marks for prior teaching experience are to be given. Number one is prior teaching experience. You need to look into the object of inserting a prior teaching experience as one of the qualifications. And where a rule also permits people who do not have the prior teaching experience to participate or offer their candidature selection process, obviously they are in a separate compartment. So prior, it's not like the promotional groups from post A to post B, you must have say prior teaching experience of the 5. Which applies to all the candidates.
Merit comes seniority, seniority comes merit.
Now here is a case where your Lordship would find two categories of persons offering their candidature in the same process. And prior teaching experience fetches a few more marks to persons who have the prior. The purpose is, what would be the purpose? Because you're not only dealing with the rule, will not emphasize this. Will not effectuates the broader aspect that is not Article 21A of the Constitution. Because this rule is confined to the upper primary level of classes, that is classes 5 to 6. Today Article 21 fundamental. Therefore, these rules what we.
Sir, why don't you sit? Please give
But
him
there's
a
no
chair.
place to sit. But I can sit on the lap of it.
He doesn't want to sit.
No, no.
He says, I'm a
Sir, please
permanent
sit.
standing counsel.
Please give him a seat.
Seat is
No, no, please. Sir, it will be very improper if you stand. Please sit.
Yes.
Please sit.
Now, the dominant aspect or the broader aspect or the more important aspect, is what, we all lose sight of. Is this rule framed only for the purpose of selection? Or it has a larger aspect in it, embedded in it, which is to offer or effectuate the fundamental rights of children between 6 to 14. And Article 21 and the follow-up legislation, that is the Right to Education Act, provides that quality education has to be provided to those children of that age group. Now, please keep, these two aspects in mind, for the purpose of interpreting the juncture at which, this prior teaching experience marks are to be awarded. First is, what is the purpose of inserting this kind of a clause? The purpose can be nothing else than to, provide or ensure that better quality candidates are selected. Now, how do you distinguish? Broadly, inter se merit is something different. But broadly, we distinguish between, for example, take a hypothetical case, not related to this matter. In a case where, say one group high secondary candidates, past candidates apply, and another group, secondary candidates apply. There, logically, if somebody says that no, I will consider the high secondary examinees or past candidates as better or in a higher pedestal than the secondary candidates, but that, in my very respectful submission, is a logical approach. But merit-wise, maybe the secondary candidates may outshine the higher secondary past candidates. So therefore, the purpose of providing this clause is to ensure that more experienced persons or persons who have teaching experiences are put in a better place for the purpose of selection. Why? Why is this incorporation? To ensure that better teachers are tried to be made available. Finally, who's good, who's bad is again something a matter of perception, performance, many other unknown things. So this being the purpose, now Milord kindly read the rules. But we cannot read this rule only to confine it to selection or confine it between the inter se merits between the prior and persons having teaching experience and persons not having teaching experience. Now please take Milord 2K, I'm sorry. But your lordship must have read this rule many times. Now, interview list means etc. in the post of so and so, a list of candidates to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score. So when I call people, I first prepare a preliminary merit score. Now I have to distinguish. Here, Milord, I should be the School Service Commission, be that as it may. So I have to distinguish between the more experienced, I call it the teaching experienced people, and the others who do not have the teaching experience. Therefore, Milord, at the preliminary score assessment stage, I have to take into consideration the merits of those persons, or I have to take into account those persons who have the prior teaching experience. Now, why I say this? Because what is the purpose? You have to look into the purpose also, because
no, you are going around the same thing all over again.
Yes.
What is the stage? 10 marks, we take it that yes, you can give, because right now we are taking it to 2025 rules as a whole, assuming that it is all right. Challenges before the Supreme Court. This is not the issue here. The court is not deciding. At what stage will this 10 mark come?
Preliminary merit score.
Yes. Where from are you getting that the 10 has to be added earlier and not later?
Please take rule number 6.
Rule number 6.
Yes. Your lordship must have been taken through Milord these.
No, 6.
Yes, I'll come to the schedule.
No, it's all right. Rule number 6.
Rule number 6 says manner of selection. Selection shall be made category wise on the basis of merit in the manner as specified in Part A of Schedule 2. Now let us come to Part A of Schedule 2.
Yes.
Which is page 89.
Yes.
Milord, Schedule 2 Part A has, Milord, 4 parts. All these, Milord, the first part is written examination, which is based on OMR sheet marks. Then 2 is academics. Now this academics, Milord, has been divided into 2 parts. That is educational qualification 10 marks and prior teaching experience 10 marks. Those who are not having prior teaching experience, for them B doesn't apply. Then is the oral interview and then the lecture demonstration. Now, Milord, based on this, Milord, prior teaching experience is part of the educational qualification which is provided under the rules. Therefore, prior teaching experience marks is part of the academic marks that a person is to have.
How do you say that it is provided within the group broadhead academics?
Yes, Milord, 1 is written examination.
Yes.
2 is academics. Now, what is academic? Academic has 2 parts. These 2 parts are applicable in respect of 2 categories of person. If a person has prior teaching experience, then into A and B applies.
Submission has been made to this extent
Yes.
that the word here in Schedule 2 is academics. It's S.
Yes.
S.
Yes.
Plural.
Yes.
In K,
Yes.
it is mentioned only academic. The
Yes.
S is not there. And this S
Yes.
considers the teaching experience, which is there in the schedule. It is not there in K.
Yes.
So,
But are
stage.
my learned friends suggesting that this is plural and the other is singular?
Right. It
Millard,
is.
Millard, general clauses Act, Millard. Singular includes plural, plural
Very well.
includes singular.
If that is to be taken, then K and L will be contradictory.
I'll come to that. I'll come to
Yes,
I'll come to that. Therefore, let us, Millard, first clear the air that in academics, is academics only confined to educational qualification, or academics will also include prior teaching experience for
Right.
those who have the experience?
Yes.
Well, my very respectful submission is, unless Millard Schedule 2 is challenged on XYZ grounds, Millard, the Schedule 2 as it is to be read, which means that prior candidates having prior teaching experience has twofold academic qualification, if I may put it broadly, and candidates without teaching experience have only one part of the experience under academics.
All right.
Now, kindly come back to Millard, Rule 2K.
Yes.
But I don't think, Millard, academic and academics would make much of a difference. One single alphabet will.
এখানে আগে অ্যাডজেক্টিভ ইউজ করেছে আর ওখানে আগে নাউন ইউজ করেছে এখানে অ্যাডজেক্টিভ করলে এটা ভুল হয় সিনট্যাক্স এরর হয়
I'll hear you. Do you also have a seat over there? Please sit. Please sit. Yes.
Now, academic score in clause K is nothing other than, Millard, the academic score spelled out in Millard Schedule 2, Part A2. Let us not go into all these things, whether with S and without S, it at all make any difference.
S means the prior teaching experience.
Yes.
Without S is only the educational score.
But in that case, please consider one thing, Millard. What happens to the persons who do not have the teaching experience?
They don't get the marks.
They don't get the marks.
Stage or that stage.
Therefore, the stage is, Millard, when, Millard, I call them for interview, I have with me the marks which they are also entitled to by virtue of their experience. That is the purpose. If I exclude these people at the threshold by treating everybody equally, at par,
level playing ground. This is the
level playing ground. In my very respectful submission, this may not be applicable universally, because preferential treatment is acknowledged and applied in the service jurisprudence.
Yes. All right, then.
Therefore, Millard, if I give them these trained persons or the experienced persons, I go a bit forward by saying that I give them a preferential treatment by adding their marks at the time of preparation of this preliminary merit score, but I would be respectfully submitting that that is not infraction of any of the known principles of our constitution or the law of our country. Therefore, Millard, if a person is experienced, Millard, the experience has to be taken note of before calling them for interview and lecture demonstration. Now, the interpretation should be as I say. Why? Because if I do not give them, because it is said, please look into, Millard, the bracket portion. It is clarified, that is, from the written test or TET and academic score. Now, what they are trying to say is that academic and academics are different. Well, with respect, possibly it doesn't make any difference. Yes.
It makes a whole lot of difference.
No.
It makes a whole lot of difference, sir. This is the 10 marks issue is there in many matters. Madam, please sit. Please sit. I'll hear you. And now the stage at which it should be added.
2K. This is my interpretation. Now let us come to 2L.
Yes.
Yes. Merit list in respect of SLST so and so means in case of post a list of candidates prepared category wise on the basis of merit, which shall mean in addition to what has been stated in 21K, marks obtained in oral interview, lecture demonstration and prior teaching experience, and shall include all eligible candidates who have appeared in the interview. Therefore, Millard, the prior teaching experience over at Millard L, Millard, if it is held or if it is interpreted to be at the L stage and not at the K stage, then Millard, it militates against Millard Schedule 2A2. And 6. But the rule by itself, the purpose of the rule is to give preference to the experienced candidates.
You give preference.
Yes. Therefore,
but then at what stage will
yes,
you give?
Millard, if I give them preference, I need to give them preference at the first stage or at the earliest stage. Because preference, the word preference itself presupposes that from the very beginning I'm going to separate both the classes.
Resources will not be augmented appropriately.
Yes. But preference cannot be Millard at the end. Preference has to be always Millard at the beginning.
Do you anticipate any candidate?
Yes, ma'am.
Who did not participate in the 2016 recruitment process to get this 10 marks?
More than 3,000 people have applied.
কতজন
More
করেছে?
than 3,000 of central government and more than 1,000 for the contractual teachers of substantive posts in state government. More than 4,000.
Applied.
3,000 plus 1,000.
3,000 was central government.
Central government and 3,000.
No, the figures, but I do not know, Millard, whether it will correct or not. But Millard, I am instructed to say,
I do not need the exact figures.
Approximately 3,000 candidates with prior teaching experience from central government institutions, schools, etc., have applied, and 1,000 from
State government has provided a list of contractual teachers and substantive post of 1,000 teachers.
and contractual teachers
In substantive post.
in substantive post in state government institution around 1,000.
Applied.
They are
And
applied.
the total appointment is around 23,000 or how many?
35.
35,000. All right.
Very well, 36 more or less. Therefore, Millard, if I have to give preference, well, there are two ways of interpreting it. What is the purpose? If the purpose is to make available good teachers, I have to give them preference at the beginning. Number two is, as they are arguing that this is creating a class between the two. Yes, we are creating a class.
No, the class is not in this matter.
The other,
Class is in
very
class
then Millard,
class
yeah,
is
I don't,
not
I don't.
We assume that the rule is all right.
Very well.
It is only the stage at which the 10 marks to be allotted is the issue.
First, to make available good teachers for the students.
In that stage also.
Yes.
That stage also you can make available good teachers.
No,
because you
no.
are adding at any case.
Millard, I am giving a preferential treatment, therefore preference has to be given
At the very first. This is
at the
main
inception.
submission.
At the inception.
That is the submission.
Then what is the purpose?
Millard, if Millard, the experienced candidates are Millard screened out or Millard.
Why will they be screened out? Because they will get the chance at that level also. Nobody is screened out at the 2K stage.
Kindly look into Millard, the interview list.
Yes.
Millard, in the interview list, if Millard, these 3,000 or 4,000 are not there, and they have to wait, Millard.
Why will they not be there? That means their educational qualification score must be less. Otherwise, they would have been there.
Millard, today, Millard, at the time of framing of the rules, or Millard, at the time of invitation or the advertisement or the employment notification, I do not know anybody's score.
Nobody knows anybody's
yes,
score.
Therefore, consider it from the stage or at the stage when an employment notification has been issued.
Right.
There, nobody is in the fray.
Nobody is in
Nobody has applied.
Right.
We do not know the inter se merits of the candidates. At that stage, what should be the appropriate interpretation? Because the interpretation should not be that the instance of persons who come before the court invoke the jurisdiction of the court, saying that I don't have the experience, therefore I'll be in the back seat always. That is what is being said. Now consider this, on two angles. One I have already said, for the benefit of the students. The other is, at the selection stage, I have to give preference or priority to those persons who are already experienced. The experience factor has to be taken note of at the earliest stage. It may even be relegated back to from the date of application itself. Because on the date of application itself, there are two, submission of application, or the last date of submission of, you have two sets of people. I can do that at that stage even.
I didn't get this. I didn't get this.
Yeah, I'll tell you. I'll explain it, Milord. I invite application. 10,000 people apply. All the applications are with me. I have invited two categories of persons. Can I not distinguish between the experienced and non-experienced persons at the very threshold after receipt of the applications? General, I'm speaking of general, hypothetically. Not Milord, connected to this case.
No, when you seek application, you seek application from all.
All.
There, what you say, that there will be a distinction between the
No, I will invite applications from all.
Open advertisement.
All applies.
Yes.
Or two categories of people apply.
Right.
Can I not give
two categories means what?
With teaching experience, without teaching experience.
All right.
Now at this stage, this is hypothetical, not as per this.
Yes.
At that stage, after receipt of application, from that stage itself, Milord, the preferential treatment or the preference starts.
Provided your advertisement specifies so. It has to specify.
Advertisement may or may not be. Finally, the rules prevail. In case
that means the rules, whatever, you should have a substantive rule according to which you can say.
My reading of the rule is that the teaching experience has to be given at the time of assessment of the preliminary merit score.
All right. Yes, madam.
Just one minute. Just a minute.
Just. You want to make more submission?
Just 1 minute.
I think Mr. Bandopadhyay has.
Just 1 minute. Just 1 minute.
I'll hear you.
The 5th August, sorry, I missed it. 5th August, Supreme Court has passed an order in the review petition. In that review petition, the Supreme Court has said the entire selection, therefore, had to be invalidated to maintain the sanctity of the process of selection, which should be pristine and free of all such inferior. However, the interest of the appointed candidates who were untainted were sought to be protected to the greatest extent possible, as is evident from the concluded paragraphs of the judgment. Greatest extent here means that this has to be protected. Experience. Now, this is the experience part is also there.
5th of August?
Pardon?
5th of August?
5th of August. 5th of.
The supplementary affidavit has been filed as 5th.
Spiral compilation.
1 minute. 5th of August order is there?
Yes. Page 281. Mr. Spiral compilation. 281. 281.
Which portion did you read?
This is at paragraph 4.
Paragraph 4?
Paragraph 4, last few lines. Above
the adverse remarks.
The entire selection, therefore, had to be invalidated.
The entire selection.
Therefore, had to be invalidated to maintain the sanity of the process of selection. We should pristine and free of all such information. However, the interest of the appointed candidates who are untainted were sought to be protected to the greatest extent as possible, as is evident from the concluding paragraphs of the judgment. No doubt, invalidation of such untainted appointments would lead to heartburn and anguish, which the court was fully conscious of. But protecting the purity of the selection process is paramount and necessarily has to be given the highest priority. Last but not the least, The adverse remarks made against the authorities concerned who are wholly and solely responsible for the adverse appearances appearing during the third of kind of untreated were fully warranted and justified. Now, my lord, the protection, this is
Whatever is protected is protected. That nothing.
But,
Supreme
but
Court has not given
no,
you
no,
anything
Supreme Court
else.
here has not been clear, but this
This goes against you rather.
protection to these 10 marks which have been given.
You give protection, but at what stage is the issue now?
Now, may I just take you, my lady, back
Yes.
to Schedule 2.
Schedule 2.
My lady's question on academics and academic score.
Yes.
Singular and plural.
Right.
Now, this is only English grammar. How are you in academics? Means English, math, so on and so forth. What is your academic performance? What is your academic score? That is the only distinction.
Tell me one thing. How are you
Yes, madam.
interested in this matter?
No, I am in 4 IAs before you.
Yes.
Untainted candidates.
Maybe.
All of whom have prior experience. Now I'll tell you, I'm answering my lady's second question.
Right.
You see, we all have prior experience. Some of us may have 3 years. Some of us may have 6 years. So inter se in this category, if you even look at the rules, I may get 2 years for 1 year's experience. I may get 6 points for 3 years experience.
Right.
Now, please see.
Of our application.
Now, please see. May I just take you back? We are just on interpretation right now, not on merits. We're on interpretation.
Give a copy. Give a copy. There was direction for circulation of.
Correction. She is not even a party in
I am in items 9, 10, 11, 12, 14.
In 10, I have made him party.
Who have you served, madam? Who have you served? The councils are here.
There was a direction on the last occasion.
Yes.
Give copies of
Who
the
did you
affidavit of
serve?
service here. Give copies of the affidavit.
Who did you serve? The councils are there. Item 9, who did you serve?
10.
No, item 9.
9 and 10.
We are in 9 and 10. They're identical, my lady.
Right, 9 and 10. Who did you serve? If there is no service, then I'm not going to hear you at all. Show me.
This is the service.
Please, onake dekhan.
9 and 10.
9 and 10, check out whether service has been affected or not. If not,
9 and
please
10
hand over copies. Yes, madam.
Yes. So on points of academics and academic score, because the rule could not have said academic score. It has to, it's a composite. It's just English grammar, my lady, nothing more. Academics has 2 components. So therefore, Schedule 2, the title, has to be academics because there are 2 components to it. Component 1 is educational qualification. Component 2 is the prior teaching experience. Both these are academics. If you ask my son, for instance, what are your academics like? What's your performance? And of course, he runs away when I ask him this. But it will be more than one. Math, English, PE, so on and so forth. What is your academic performance? What is your academic score? That is a composite. So it is only on English. It is not contradictory. Nothing needs to be read out. That's the first submission. Now, please see the second submission. Please go to prior teaching experience, 10 marks. My lady has that, Schedule 2. At the secondary level, in a government or government-aided or government-sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or contractual basis. So this could include those who are not part of the 2016 recruitment cycle. This could include those who are part of it. This could include those who are in government teaching positions, or this could include those who are on contractual positions. So
No,
the
it's
net
all
is
right.
very wide.
All said and done.
Yes.
The stage. You get the marks.
Yes.
What stage?
Now the stage. Now please go to Rule 11.
Yes.
Rule 11 makes it clear, and then I'll come back to 2K and 2L. Rule 11, my lady has this.
Yes.
In my compilation, it's 541, but be that as it. Method of SLST for selection of candidates and preparation of the panel. The method for selection of candidates. Now, please turn the page over. Please see the sequencing that happens. Rule 10, this is 11, subclass 10, my lady. Preliminary list of shortlisted candidates, step 1. Thereafter, 11, regional commission shall verify the credentials. So at this point, I have taken the exam. I have given my educational qualifications, which are in academics. Please see, that is in schedule 2.2, academics. So at this stage, 11, there is a verification of schedule 2 that is happening. This is step 2. Step 3, 12. The regional commission during document verification in case of any doubt on disability. So any other specified categories, there may be other categories also. Step 4, so 3 continues. This is verification of documents. What documents? Educational qualifications. This is criterion 1 of academics. Now please go to 15. The Central Commission, the Regional Commission submits these report to the Central Commission. The Central Commission, after we have finished this process of academics, which includes educational plus prior teaching, now step 3. After this, the Central Commission shall prepare a consolidated interview list, which shall be published and be forwarded to the interview board. After academics has been assessed, this composite list, step 3, is sent to the interview board. Step 4, the final step. After the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list. This is the final stage. The culmination of 1 to 4 is step 5, which is the merit list, which, my lady, is L. That is the final stage. The rules are harmonious. We may have belabored its explanation, but the rules are in consonance with the steps which the rules provide for. It is in consonance with English grammar, and it is in consonance with the idea that a seminal idea which the Supreme Court has long upheld. It is within executive and legislative domain to fix qualifications. There is no preferential treatment here. We are choosing the best possible teachers. That includes educational qualifications, that includes prior teaching experience, that includes performance in the interview. Very well.
I have a direct answer for Lordship's
Yes.
question. When it will be, my first point is it is absolutely clear when in the rule itself there may not be any requirement of any kind of interpretations. Kindly see first 11 Roman 8. Well, this is a substantive part of the rule. There is a difference between definitions for the purpose of finding out what does it mean and what is to be done. Now, what is to be done at 11.8, kindly look at two things, presence and absence. Presence of K and absence of L. So, 8 equals to, kindly, if I read, the Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview. So therefore, pre-interview. So there is no confusion. Subject to verification of credentials, it's not relevant, and eligibility category-wise on the basis of, now this is preliminary merit score as defined in Rule 8.1a. Lordship conspicuously finds that it's not the definition of merit that is not there. The definition of interview list that is incorporated. Then, Lordship kindly come to straightway schedule itself. Well, when Lordship's query is at what stage? 1 first, 2 second, 3 thereafter, 4, and that's the thing. Kindly follow that the simplest thing, schedule 2, A equals to capital A equals to the entirety what is required to be done. It's not what exactly pre-interview, all. Now 1, 2, 3, 4, kindly come 1. Exactly that was the beginning written, done. 2. Now 2 has 2 components. 2 has small a and small b. Now kindly see thereafter 3. So chronologically, this 3 for 9, 10 and also for 11, 12, it is coming after 2. If I just say once more, there is a clear chronology under the schedule. 1, 2, 3, 4, Yes, 4 ultimately ends at lecture demonstrations. So there, my lord, the oral interview comes as 3, whereas the prior teaching is coming under 2. So the question before your lordship is at what stage? It is at the stage of pre-interview because of the 2 reasons. Reason number 1.
When is the interview going to be held? Any idea, Commission?
Well, it has to be after the list is prepared.
That I understand. How soon are you expecting to prepare the interview list?
The verification process will go on for till 17th, 18th. I'll take
Till?
instruction till 18th. I'll take instruction
Is it after the 26th
I'll take instructions.
or before that? If the
Tentative schedule,
The advertisement they have given, but
that is not being followed.
that is not being followed.
Assuming the Supreme Court interferes and says that 10 marks will not be there, as was submitted by Mr. Mitra on the last occasion, then the stage issue comes later on.
Stage issue, may I say?
Right.
May I just conclude? My lord, the stage issue can only come if there is any kind of confusion, as was sought to be said.
Now they are raising confusion.
Now they are raising,
issues.
correct, they are raising. I'm not saying that they are not raising, but once lordship look at from this angle, when it is clearly said as 1, 2, 3, 4, and 3 equals to oral interview, now then lordship has to somehow change this rule. I'm not saying that is impermissible, but that's a different thing altogether. As far as the
you say this is the chronology, they say that is the chronology.
No, I don't say the chronology is the only reason. I say this is the chronology. So the rule itself shows that before oral interview, it has to be calculated, number 1. Yes. And the direct answer is the substantive. The substantive says 11.8. I would be only praying before lordship to see the absence of L, because their entire submission is on the basis of definition of merit list. That comes later on. Lordship, kindly see that in Roman 8, there is an absence of. So therefore, how interview list has to be made, that is clear. Nobody is required to interpret it. They could have simply said, you also add the M. You also add the L. They have not. So where merit list comes, kindly look at Roman 16. Much after. And if you lordship kindly take the definition, it would be clear also. The merit list is something which comprises of everything if there is a requirement. It is not a double marking at all. Because for primary, that chronology is different for the prior teaching experience. That's they thought it. Kindly look at my lord, this K. So K is the clear answer. What should be the interview list? Number 1. And that says on the basis of the preliminary merit score. Now, where the preliminary merit score comes, is it before oral or after oral? Schedule 2 is clear. Now, their entire submission, if I take it, is they're banking on L. L equals to merit list. Now, if lordship kindly see a definition of the L, it is possible to say that there is some kind of, if I say, contradiction. But that is contradictions in the definition clause, not in the substantive clause. Substantive clause 11 Roman 8 clarifies that this list has to be done on the basis of the K and K only. And in that context, assuming that, my lord, there is a confusion, there is a direct judgment. That this judgment, my lord, takes this part. Kindly take the definition clause 2. This is the kind of rule which begins with 2.1. Kindly take my lord 2.1. In these rules,
I'll fix this matter later on. Please come. Heard submissions made on behalf of the parties, including the applicants' interveners at length. Stuff. Release the matter once again on 28th of November 2025. supplementary affidavit filed on behalf of the petitioner in the matter of Rahul Mondal and others
Let them prepare the list, but not for
be taken on record. Stop. Next.
যেটা দিল তখন না তো রুলস আমি ম্যানেজ
In the last day's order, it has been recorded that the fate of the examination will abide by the result of the writ petition. That order remains.
That order continues.
So that order continues. And just wait for the Supreme Court to make any type of interpretation, or if you all can get hold of any one line which says that this court can go into all these things, then with an open mind, the court can decide. Otherwise, it's always playing at the back of the mind that anything will touch that 10 marks.
Yes.
Anything, any order passed here will touch that 10 marks issue.
But this issue would never be gone by the Supreme Court.
Suppose the court says that the 10 marks will not be there at all.
That is fundamental.
That is the main thing. Then no question of former, later, now, later.
But if the Supreme Court says...
Right, then this is there and the interim order is also there.
Okay, keep your guys.
10 marks, they can always calculate. Let us see.
There is already an order to abide by. There is no reason.
Yes.
And this is not that kind of matter that they can seek a stay of entire proceedings.
Nothing of that.
On
Yes.
20th November, one clarification. Will my lord hear me or not?
I will certainly hear you.
Then he will.
I have heard you. Today also I have heard you. And I'll hear you on the next day
I
also.
would have avoided all the complications.
You have, sir.
How to read a statute? That's
Yes.
the big question.
Yes, sir.
That's
Next day. এক minute. 9. Yes, yes. For what? No, sir. You must be filing your intervention application. That is on record. What affidavit will you file? What affidavit will you file? Your application is in your support. What further application will you file? Don't add up documents. All right. Can যতগুলো আছে না allow করে দেন.
My lady, just one
The
small point.
documents to be circulated, did you interveners?
Yes.
What about the copies? Did you get it? Copies?
Yes.
Other cans?
My lord, I have not received.
See, somebody
will
has not
please
received.
give
Please
copies.
give.
Can.
Please give.
Don't be stingy on photocopy.
To avoid
copies.
My lord, we are involved with the 4 matters, my lord. All the matters we have solved and I have the affidavit of service planning.
See, the court is not concerned with the affidavit.
My lord, any of the matters.
Papers should be there. The court is happy.
Hand
No
over.
question of law. But to avoid further confusion, logically record note, this issue does not relate to the constitutional validity, but relates to the applicability of the rules.
Last day's order, what is the issue is clearly recorded. I will not add anything.
My lady, my submissions are for all the cans that I'm appearing in, my lady. So
You file it today, you file it on the next day, it will be the same thing.
yeah, so it's the same submissions for all of them. We've got them very briefly for my lady's consideration.
Give it. It is the same thing.
Yeah, it's the same thing in all the cans.
Same order will go down in item number 10.
My lord, only one thing, your lordship is allowing these
9, 10,
applications.
11, 12, 14.
Let
my
it
lord.
be added because I'm hearing them.
Yes, my lord, only one thing. Then department may be directed to amend the cost title because
cost title amend করবে intervention
Right now,
এই হিসেবে
intervention হিসেবে থাকছে
let them remain. Let them remain. They have been allowed to participate in the proceeding. The court has heard them.
Yes, right. My lady, I hope I'll be able to come back to my lady's court.
Please
Hopefully.
do.
That's
And
my-
enjoy the city.
That's my hope. Yes, I'm
It's
grateful.
a nice weather right
Beautiful
now.
city.
Please
Grateful.
do.
আমি জানি না
take the item number 5.
5 and 6. These SSC's matters are over, isn't it?
There is only item
Oh.
13. Similar thing in a different way.
13 has been marked. 13 is the same thing.
14. 14 is
14 is
the B and group C.
13th has been already fixed. Order হয়ে গেছে তো 13 তে? 13 হয়ে গেছে। 14, right?
13 is different.
14 is
14 is, my lady.
না, দাঁড়ান।
14 is segregation within the class.
Which one? 14?
14.
Who are the applicants? Please check up. Give a phone call. Then serve copies. Please serve.
I want to ask you because for the unlimited teacher of 11, 12, I apply. And the rule is specifically qualification and voter protection is the difference. So, whether
can number 1
is eligible, but the teaching experience mark for the 11, 12. They have applied because one of the rule is there, but there is the two categories. If the 9, 10 the untainted teacher applied in the 9, 10 school and 11, 12, if the marks will be given for the both, so double benefit will be given. That is our contention. We are the untainted teacher for the 11. So, the rule is
You do not want the 9, 10 teachers' experience to be counted. Or 11, 12.
Because the rule is the different and education quality is the difference and selection process is the different. So, school service commission, what to stand?
All right, let us wait and see whether the Supreme Court upholds the 2016 rules or the 2025 rules. If the court upholds 2016, then all goes. If 2025 is upheld, then the court will look into all these things.
Kindly recorded my submission and if the 19 teachers will get the benefit for the 11, 12 course because they will be benefited for the one class. If they will be benefit for the two classes, but double benefit will be given. But that is not permissible under the law.
Listen. A candidate will get one selection either in 9, 10 or 11, 12. Right? Now you say that their experience in 9, 10 cannot be counted for 11, 12. This is exactly your submission.
Application there also.
Because
right.
They are the untainted for the 9, 10.
We are right now not in tainted and untainted. Right now the issue is whether 9, 10 qualification can be taken up for consideration for teaching classes 11 and 12.
They have no experience in the 11, 12.
They have no experience in 11, 12. Item number 14 একটা order লিখুন তো। The petitioners raise an issue.
But I also have an application.
With regard to the selection process initiated by the West Bengal Central School Service Commission for appointment of assistant teachers in accordance with the rules and নামটা একটু দেখে নেবেন তো 2025 rules. ঠিক আছে? Submission is that the authority cannot take into consideration the experience of candidates teaching 9 and 10 for recruitment in classes 11 and 12. This exactly is the issue.
But I have can 2.
I have can 1, item 14.
All right. The broad issue as to whether the 2025 recruitment process can be adopted for the recruitment or the 2016 rules will apply is pending consideration before the Honorable Supreme Court. Stop. It has been brought to the notice of the court that the matters are fixed before the Honorable Supreme Court on the 24th and 26th of November 2025. Stop. Next. Let this matter be posted on 28th November 2025. Stop. There are several intervening applications in the instant writ petition. Stop. Let copy of all the intervening applications be served upon the learned advocate representing the petitioner. Stop. The copies of the applications shall also be circulated amongst the parties. If served, then there is no reason for double service. Just ensure everybody has all documents, nothing more. Yes.
Only one right in your lordship order.
Which order?
The last
14.
Just one. Whether 2016 rules or 25 rules, there are other issues also. Just add, if it comments to your lordship.
Where?
In your lordship
matter?
order, in the honorable Supreme Court, all issues are covered.
Whatever is there before the court is
Your
there.
lordship is pleased to record, whether this rule or that rule.
Yes.
That particular
That will cover everything. No, nothing. 5 and 6. Yeah, that was the submission I have recorded.
25 rules specifically is there.
Yes, item 11 to hoye gache.
And item 11 will be the same order.
Yes.
13 is
only item 13 will be different because it is for group D and C, which is
non-teaching.
Group D and group C. Here it is not a teaching experience, similar experience.
And it's
Now,
different
so therefore,
and the issue is
this
different.
not there before the Honorable Supreme Court. But I don't know whether Lordship wants to hear it now or
Item 13.
Item 13, there is a separate rule.
The counsel for the petitioner agreed to pass the same order in respect of 4, 7 and 13 has been tagged.
Done so incorrectly because
then if the petitioner has done it incorrectly, let the petitioner do it. Let it be.
Only thing there is
Canta.
there is an addition in party in item 13. There is a one line in that.
Can 1, 2 is there.
IAPA for the can 2. আমরা can 1.
Can 2.
Can 1 আমাদের.
Can 1.
Application of addition of party. Item number 13. আচ্ছা 13 এ একটা লাইন লিখে নিন the learned advocate representing the interveners have been heard. Stop. The interveners will be heard on the next day also. Yes. All up.
This is the affidavit of service, my lord.
Yes.
This is a question of, my lord, the higher scale of pay. The petitioner first has been appointed, my lord,
5 and 6. Only 6 here.
in a school.
Is there? Other side is there?
Item number 5, my lord, Mr. Biswajit Dey is appearing. He is engaged in another courtroom, my lord.
My lord, your lordship kindly take this matter up Both
One
these
minute. 1 minute.
60
This is so 118. It's past recess. The courts are sitting. Please
Yes,
come
my lord.
us now. What is the matter?
My lord, petitioner, my lord, after getting appointment in a school under the Bardhaman, my lord, thereafter he passed my lord, the MA examination. And my lord, thereafter he seeks.
Postgraduate scale of pay. Where is your application?
My lord, there is two applications, one in the district of Bardhaman and thereafter.
Has it been considered?
No, my lord.
No.
Thereafter, she has been transferred to the Howrah.
Yes.
And my lord, thereafter, he again made an application before the district inspector of schools. My lord, let it be considered.
Page.
My lord, prayer for my lord, that is page 57, the last application.
The petitioner
My lord,
seeks
within
higher
the
scale
time
of
bar.
pay. Stop. Her application seeking higher scale of pay is pending consideration before the district inspector of schools.
AC Howrah.
Secondary education Howrah. Page 57.
Yes, my lord. Annexure P21.
I have got only 56 pages, but your application is here. Acha. Without entering into the merit of the same, the instant writ petition stands disposed of by directing the district inspector of schools, secondary education Howrah, to consider the petitioner's prayer in accordance with law and in line with the judgment laid down by the special bench of this court in the matter of Utpal Kanti Koron and others versus State of West Bengal and others, reported in 2024 SCC Online Cal 1274. At the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Now I take it 12 weeks, Korun. An opportunity of hearing shall be provided to the petitioner for production of all documents in support of her prayer. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, comma, then necessary consequential steps shall be taken by the said authority. Disposed. Service is taken on record. Yes. Next one is also same.
No, my lord. This
Different.
is
What is it?
my lord, this is my lord, regarding my lord, the CPF to GPF.
Yes.
My lord, the widow has come to before your lordship. Because my lord, the pension my lord has been
You
given.
got similar order?
My lord, I have done.
Please give.
My lord, it has also been corrected in my way.
All right. Who are you for the state? All right.
আমি তোকে একটা কথা correction করে দিই।
From the date of
There are similar orders for widows also.
From the date of
My
return.
lord, I have corrected that wherein the husband, I have corrected the widow. Every page I have corrected. I have carefully corrected.
আমাদের কাছে widow আছে, CPF, GPF, widow.
From the date of retirement.
My lord, from the date of retirement. He paid for date of retirement. That was not paid to the original petitioner. Original, my lord, the pensioner.
এখানে একটা দিয়েছে, আমাদেরটা দেখে নেবেন আর এটা দেখবেন, সেম হলে দিয়ে দেবেন। Disposed.
Grateful. You have service in both the days.
Well, 15 for the petitioner. Well, the issue regarding pay protection from primary teacher to shifted appointed as a secondary teacher. Well, there was a direction for file affidavit. Well, till date, well, they have not filed affidavit. And in the meantime, my lord, my prayer, my lord, there is some documents I have, my lord, collected. My lord, I need to, my lord, file by way of supplementary affidavit. So, my lord, it should be, my lord, bringing before the honorable court. So, kindly give, my lord, only, my lord, 7 days time. So, I can, my lord, come, and in the
Learned
meantime,
advocate for the petitioner seeks time to file supplementary affidavit annexing documents which will be required for the purpose of effective adjudication of the instant writ. Stuff. The affidavit in opposition directed to be filed has not been filed till date. Stuff. No direction for affidavit.
No, my lord, order dated 5th March 2025. Kindly consider 5th
March.
Page 2.
Yes, opposition. Not been filed. What about the opposition? Let supplementary affidavit be prepared and circulated by 21st November.
Yes.
Affidavit in opposition to the main writ petition and the supplementary affidavit shall be prepared and circulated by.
I have the report with me.
You have the report? All right, 12th of December. Release the matter on the combined monthly list of January 2026.
Well,
what is the application for?
For application, initial petitioner file for, my lord, he want to go back in the primary school.
All right.
That application, my lord, my instruction here.
Not to press. Record. Learned advocate for the petitioner submits upon instruction that the petitioner does not intend to press the connecting application being Can 1 of 2025. Stuff. In view of such submission, let the connecting application be dismissed. Next. (16)
That affidavit, my lord, peremptory loss. Otherwise, my lord,
they will prepare it certainly.
That order maybe. Otherwise,
there is a direction for filing of evidence.
You didn't file. It was in March.
Kindly extend the order.
I have extended the time, but please do it this time.
Okay.
Yes. Retired teacher not getting the pension.
Yes.
What has happened? State respondents.
Yes.
Submitting report, my lord.
Yes.
Report, my lord.
Give me the report. What does the report say?
My lord, requirement date was 30th June 2025, and my lord, as per my lord, as the pension section authorized, my lord, copied the pension file in due time and forwarded the same to the DDA. And DDA Purbo Bardhaman raised some objections, my lord. So it is that.
Listen, whatever the objection, it has to be settled and he has to get his pension. Why don't you take it up with the school?
My lord, DDA Purbo Bardhaman has already sent the objections to the school. The school has kept it pending.
Please come. The petitioner, who is a retired teacher, is not getting his pension. Stop.
Other service benefit.
The District Inspector of Schools, within bracket Secondary Education, Purbo Bardhaman, has forwarded a report to the court. Not to the court. Forwarded a report wherefrom it appears that certain objection was raised with regard to the pension file of the petitioner. Stop. The school authority was requested to comply the objection raised. Stop. The school has not acted in accordance. School has not proceeded to clear the objection that has been raised. Stop. Paragraph. The school, is the school a party? You give a copy. With all documents?
Yes, ma'am.
Is the school a party? None represents this school. Stop. Affidavit of service is taken on record. Stop. As the petitioner has retired from service,
30th June 2005.
On 30th of June 2025,
Yes.
accordingly, he would be entitled to receive his pension. Stop. The District Inspector of Schools, Secondary Education, Purva Bardhaman, is directed to take up the issue with the school authority to make the pension file of the petitioner ready and ensure that the petitioner receives his pension without any further delay. Stop. The school authority is directed to cooperate with the District Inspector of Schools for the purpose of complying with the direction passed herein above. Stop. The District Inspector of Schools shall take all necessary steps so that the petitioner receives his pension latest within 27th March 2026. Writ petition disposed.
All other service benefits maybe.
You want other service benefits also? Is it
gratuity, public information?
nothing you've received?
Nothing.
তাহলে উপরে যেখানে পেনশন লিখেছিলাম না সেখানে পেনশন অ্যান্ড আদার টার্মিনাল ডিউজ আর এই লাস্টে যেখানে লিখলাম একদম শেষে যেখানে বললাম সবকিছু পেয়ে যাবে পেনশন উইথ অল হিজ টার্মিনাল ডিউজ। হ্যাঁ, ঠিক আছে। ইয়েস, নেক্সট। What is the matter?
Matter is for my enhancement of the salary mark, madam.
Enhancement of salary?
Yes, on the part of the attending the higher education.
So pay scale.
But on 6/11th, I submitted the instruction, madam, on behalf of the DISP.
I'm passing it over for the time being. Let him come. Call the next one.
I am for the petitioner, my lord. The matter is related to the selection of the special education teacher. And yesterday, your lordships, it is also the upper age limit relaxation, my lord. Your lordship yesterday dismissed the matter, item number 130, madam.
I fixed it when?
No, it was dismissed, my lord. Item number 130.
It was dismissed?
Madam.
So your case will also be a dismissal case?
Madam. Relaxation upper age limit, madam. Special education teacher, my lord.
Item number, yesterday item number? Yesterday item number?
130.
130? Same order will go down. Same order 130 লিখে রেখেছি 11/11 Yes, service is taken on record.
No.
Service is taken on record. Next.
My lord, I am for the petitioner. My lord, I am a part-time teacher. I am wanting prior teaching experience marks. My lord, I am working in a sanctioned post, page 22 and 23.
14th, my lord, there are
No, 14th are for, my lord, central schools and everything. Not on this. This is a government-sponsored school.
20?
22
and
23.
And two teachers.
Only sanctioned, it is a single post, and I have made DI as a party here.
The advertisement mentions about contractual and
permanent and in a substantive post.
no substantive and permanent and some
Permanent and
contractual. Permanent and contractual, not the part-time. What is your submission?
First of all, the rules is very clear. I cannot include part-time.
Yes.
Contractual
So far
include
as whether it is a substantive post or whether they have any positioning or not, the DI can come up with a report. In some other matters, Miller has directed the DI to come up with such.
Only for the purpose of finding out whether they are working against sanctioned posts or not.
Even for appointment of part-time, what mechanism the school has adopted?
Mechanism,
Yes.
this is something
What
we
is
cannot
the
add.
mechanism for engagement of contractual workers?
It has to be approved by the DI.
With deepest of respect, contractual teachers.
No, contractual, they just take it and they permit the teachers to work on contract. There is nothing in between, all backdoor appointments.
Only, my lord, in case of para teachers, it is under Sarva Shiksha Abhijan approved by the school.
It is all.
Subject to correction, let the DI first submit a report that whether this is a substantive post.
My lord, prima facie, the school is saying so. School is saying so.
School has no authority to say.
All right.
If it is not substantive post.
Please come.
My lord, DI is present. Let the
DI is present, but he is not aware. He has to take instruction.
Because when it is a substantive, there must be approval by the DI.
See, find out.
Yes.
And
There must be approval.
the petitioner
obviously post petition
intends to participate in the selection process for the petitioner intends to avail the benefit of prior teaching experience in the recruitment process for appointment of assistant teachers for classes 9 and 10 and 11 and 12, initiated by the West Bengal Central School Service Commission in terms of the advertisement dated 30th May 2025. Stop. The petitioners have annexed certificates issued by the school authority in support of the submission that they are working as part-time teachers against sanctioned posts. Stop. Paragraph. Learned advocate representing the state respondents is directed to obtain written instruction from the concerned district inspector of schools as to whether the petitioners are working against sanctioned posts or not. Release the matter for further consideration on 28th November.
Can it be on 17th? Because only difficulty in the meantime, my lord, marks will be given.
In all matters, it is the same thing.
My lord, other matters that have been fixed.
Same thing. Whether you'll get 10 marks or not get 10 marks. As it is, you are participating. It's only the prior experience.
Not that I will not even call for the interview if that may so happen.
It may be. You never know. Service is taken on record.
And Didi.
Next.
20. Lord, I'm for the petitioner, my lord. It's a transfer application offline. Page 80 is my application, 8081. My lord, I'm a single subject teacher. Lord, my prayer is
pending.
Yes.
School authority.
Now, there is one thing, my lord. School, it is, since I'm a single subject teacher, it is to be decided by the DI. School has no authority. School is to just simply forward it to the DI. Because DI, as per 3rd January notification, DI is to make the arrangement.
All right, disposed.
No, my lord, one observation is required, as your lordship observed in the last order, that the alternative requirement of alternative teacher will not be a bar. That may be recorded, that your lordship.
It will be recorded.
May I hand over the order, my lord?
I have it with me.
Very well, very well, very well. Grateful, your lord.
Single teacher.
This is my affidavit of
Single teacher pending before the school authority.
3rd January, my lord, it's to be.
Yes. You have that কোনটা দেখাচ্ছে একটু দেখি, let me
Yes,
see
your
the
lordship,
order.
first order
দেখি
on
দেখি।
this matter. That observation your lordship made, that non, yes, need not to. School need to forward it to the DI. Your lordship directed that. Yes, that's what I'm submitting. It is to be forwarded to the.
Petitioner submission,
No, no, I am submitting that the non getting of the alternative
let
teacher.
it remain inside.
Yes.
দেখে নেবেন আমাদের কাছে কি আছে single teacher.
Yes.
What is this? DI. हाँ.
DI কি বলছে?
That means it's pending before the school.
Yes. Let school forward.
That's not forwarded. No objection not given.
Yes, yes, yes.
All right, next. This post.
Next, affidavit service রাখবেন আগের ম্যাটারে। Affidavit service.
21.
Yes, I am for the petition. Page 93, 94.
Is it a single teacher?
No, he is not a single teacher.
Pending before the
School authority.
Yes.
NOC is to be given and forwarded to the DI.
medical ground, medical.
No, no, general ground, general transfer. 21.
1 minute. This is Badol Das.
এটা বাদল দাস তো?
22, I am for this.
21.
No, this is Marija Khatun.
21 হয়নি।
21 হয়নি।
দেখি দেখি ওটা অন্য অন্য কাগজ ঢুকে গেছে, তাহলে দিন আমাকে আগেরটা দেখি, তার আগেরটা দেখি।
NC 390, school authority. NOC is to be given. And general transfer, my lord.
All right.
General. The next.
Then Badol Das.
Badal Das.
So I am for the stage.
All right. Stage.
Kindly come to page 80. This is the online transfer application. My lord, DI has committed a mistake. It is a single subject teacher, but DI committed a mistake. Kindly see the second serial number, 29th August 2022. DI is sending it back to the school authority with the remarks to follow the notification dated 22nd of September 2021, which was the predecessor of 3rd January 2022 notification. So by that time, 3rd January 2022 has come into effect. The second mistake DI has committed, the said notification says the DI will take the step. School has no role to make alternative arrangement. DI has wrongly sent it to the school and saying that you make an arrangement, taking advantage of the same.
Where he has said.
Kindly see the remarks. HOI is requested to follow memo number such and such.
Yes, so this was not present in 22. The January notification came into effect.
The notification says that DI will take the alternative arrangement, not the school. DI has shifted the burden on the school to make the arrangement, which is not correct. And secondly, taking advantage of the same, the school returns it back to me.
Anyway.
My lord, in that case, your lordship's order may be referred to.
Petitioner has been challenging the rejection order or one of the
No, I'm not challenging.
of the DI. That action is being taken. When, my lord, 2025. Well, that has been rejected on 2022.
Yes. The portal is suspended since then. I cannot do anything.
Suspension, you did not have any remedy on the Muksosi portal.
All right.
My lord, your lordship's order may be referred to. May I hand over a copy?
No, I got it.
He is a single subject teacher. আচ্ছা এটা মারিজিয়া খাতুনের এটা ঢুকিয়ে দাও হ্যাঁ এটা বাদল দাসের affidavit of service.
Leave will be given to the petitioner to make fresh application. Yesterday this order has also
Very
been
well,
passed.
very well, my lord. And my lord, it may not be withheld on the ground of single subject.
All right.
That much, my lord.
এটা 22 হলো সিঙ্গেল সাবজেক্ট টিচার লিখে রেখেছি আর একটা
এই
টু মেক
তুমি
ফ্রেশ
কিন্তু
অ্যাপ্লিকেশন
তোমার জন্য করেছি কিন্তু ফাইল আমি এটা
ওটাও করা আছে আমাদের
ওই যে বলবে না কিন্তু
একটু দেখতে হবে
কি
আমি জানি না কার কাছে হ্যাঁ হতে পারে নেক্সট 23
my lord. My lord, I have filed this বলো
because my lord, it is jurisdiction of Jalpaiguri.
My lord, may I say one thing?
Jalpaiguri.
The previous bench allowed one matter. Mr. Roy only informed me that since it is to be decided by the commission ultimately, so his lordship did not consider it. That because my address is at this district, my address is at Howrah. Only my school is over there. I want to come to Howrah, and it is to be finally decided by the commission. So, my lord, the jurisdiction.
Before school, my lord, school
Yes.
considered first.
Finally,
School is in Jalpaiguri.
Jalpaiguri, but finally,
They are after-
my lord,
they are
commission has the overall jurisdiction. Finally, commission is to decide this.
Please come.
My lord, kindly allows this commission is to take the final decision. I want to come here. My cause of action is here. My home is here.
Yeah. Petitioners is.
Oh, my lord, your
the
lordship,
school
there is
within
the
the
bench is not sitting
jurisdiction.
over there. Your lordship has jurisdiction this week.
I am aware of it,
Yeah.
but even then I'll send it over there.
No, today
Because
my lord,
when you
lordship has
filed the writ
jurisdiction.
petition, the bench was there.
Yeah, another my lord, kindly today, my lord, kindly.
See, you appeared in so many matters over there.
No,
Get it done
kindly, my
over
lord,
there.
today.
Somebody else will file an appeal and say that the order is ab initio void because the court didn't have the jurisdiction.
Today, your lordship has
Forum
jurisdiction.
non-judice. No.
Very
ইয়ে করুন
good.
তো।
Very good.
Within the jurisdiction of district of Jalpaiguri. Stop. She seeks transfer.
He.
Acha, he. His application is pending consideration before the school authority. Stop. Learned advocate representing the commission raises an issue with regard to the maintainability of the writ petition before the principal bench. Stop. Paragraph. As it appears that the subject school where the petitioner is teaching is within the circuit bench of Jalpaiguri. Accordingly, the let this writ petition be transferred to the circuit bench.
And to be renumbered accordingly, my lord.
Yes, yes. Department will take necessary steps to renumber the same.
Well,
Stop. List the matter before the next available circuit bench.
Grateful, man. But ultimately, commission is to take decision who has overall jurisdiction over West Bengal.
Let this order be passed in Jalpaiguri.
The circuit bench is not functioning. Your lordship can also pass.
এখন বলবে হয়ে গেল এখন ওটা তুলে পয়েন্টটা তুলে এখন বলবে my lord, Mr. Roy only told me that you file.
Then matters, some matters, my lord, honorable justice.
Yes, 24.
Mr. Roy only instigated me to file. Yeah.
24.
24 দেখি Yes, my lord, this I have to say something. This is a blood cancer patient. My lord, kindly come to page number 101. Kindly come to page number 101 because it has been dealt in a different manner. Page 101.
Yes.
My lord, the commission sent it to the commissioner first. Now, my lord, no step was taken. I moved another writ petition. Next page is the writ petition, relevant portion, my lord, at page 103. The honorable single bench was pleased to direct the commission to take a decision on this. Now, my lord, commissioner of school education to take a decision since it was pending before the commissioner. Commissioner takes a decision, page 105, relevant portion, at page 106, requesting the commission at the last paragraph, 106, last paragraph. Hence, the school service commission is requested to recommend the transfer prayer of the petitioner to Modhamgram High School, such and such. So, the commissioner requested the commission since the commission is the recommending authority. Now, my lord, what happened? Kindly come to page 108. Commission says, commission returns it back to the commissioner on the ground. There exist many applications pending in the same subject to the petitioner in Modhamgram High School. Therefore, I'd like to request you to issue administrative transfer under section 10C, which is completely different. I have two grounds to agitate. Firstly, merely some people have made an application through online portal which is not even functional today, that does not cast a bar or a reservation over the posts. Many people can make applications. That does not mean it will be blocked.
What are you teaching?
I am teaching, my lord, physical education.
Physical education.
And my lord, secondly, it cannot be converted to 10C. It is under 10B.
Is there any vacancy over there? Physical education teacher.
Modhamgram, it is not filled up. Vacancy is there.
Is there?
Yes, they are saying many applications are pending.
Is the vacancy there?
Vacancy there. That's what they are writing. There exist many applications.
DI, who's appearing? Are you aware whether there is any vacancy in this Modhamgram school? No. Please come.
Only one thing, my lord. Kindly take the next page. I have offered other 4 schools. Those have vacancies. Next page, kindly see my representation. Last paragraph. So any of the schools, my lord, since he's a blood cancer patient.
Modhamgram APC.
বিদ্যায়তন,
ABC
ঘুষটিয়া,
Vidya-
ক্ষেত্রনাথ আর বারাসাত, that would be বারাসাত, কালী কৃষ্ণ গার্লস হাই স্কুল and মধ্যম.
Where are you now?
I am presently at the school is the name of
Not 24 Parganas.
Gopalnagar.
Ah. So is Modamgram close to your place?
That would be close to my place because the family stays.
You also seek for Barasat?
No, since the vacancies are not available, so I had given according to the choice.
Please come.
Because vacancies there in Modamgram.
The petitioner is suffering from blood cancer. She sought for
পাঁচটার মধ্যে যে কোনো একটা
transfer
বলে দিয়েছি তো যে কোনো জায়গায়
in a school near to her residence. Stuff. The Commissioner of School Education recommended the transfer of the petitioner to Modhamgram High School. Stuff. The Commission intimated the Commissioner that there exists many applications pending in the same subject of the petitioner in the said school. Stuff. Next. The petitioner has indicated her preference in respect of 3 other schools where she may be accommodated. Stuff. Paragraph. Learned advocate representing the state respondents is directed to obtain instruction from the concerned district inspector of schools with regard to the vacancies in respect of the physical education subject in the Modhamgram High School. আর এখানে আরো 3টে নাম আছে, একটু লিখে নেবেন তো। 1, 2 and 3.
3 would be বারাসাত.
ঠিক আছে?
বাসাসা, it has
page 109. Released the matter on আজকে 26th. Written instruction.
Grateful to Lord.
Service is taken on record. Next.
আছে আমার আছে? Oh.
25.
25.
I'm for the petitioner.
I'm for the state.
Wow.
Yes.
The petitioner applied for transfer. He is a physically handicapped. His application was pending. You will also kindly see status report of the Utsosri, page 43. School has not yet issued the NOC. At that time he moved a writ petition. That writ petition was ultimately dismissed with liberty to file a fresh application. Probably some documents, all documents were not produced. Direct the school authority to give NOC the physically handicapped, transfer on special grounds. It is the clearly permitted the physical handicap to transfer.
Petitioner has to make an application in prescribed format before the school authority.
That was done in Utsosri.
If your lordship kindly comes to page 45, petitioner made one representation before the school authority for issuance of NOC. It is better to my lord make an application in prescribed format before the school authority.
Offline printout and process.
Yes, it was page 45. It was submitted subsequently, but the Utsosri page 43. NOC not issued by the MC regulations. This is the school cannot.
Listen, it was in 23.
23, that is I moved a writ petition at that time.
Yes, but and the court did not allow it.
Court did not allow. Court simply dismissed with liberty to file a fresh application.
Did you file it? Did you file fresh application?
No. Court dismissed the writ petition since the all documents are not annexed.
Oh, not on merits.
Not on merits. Page 55. You'll also kindly see. Not on merits.
There is one submission.
All right. So you want your application. I can see one prescribed format application is there, page 47. What is the date of this? Did you file this?
Page 47.
40. Yes, 47, 48.
No, this was included the page along with page 46. complaint, my lord, the DI also has received. I submitted to the DI.
Not to the school.
No, my lord, it was submitted, my lord, through SOSI portal.
Page
To the school.
47, 48, was it submitted before the school?
No, page 45 through school. Page 45 to headmaster. Through headmaster, my lord, the address to the president of the managing committee.
There are certain details which are required to be mentioned in the application for transfer. So why don't you give all the details so that the school can take steps?
The development in between, my lord.
What has the development?
Is this in my matter only? There is a development. I must appraise your lordship. Matter went before the honorable division bench. The honorable division bench said that unless you make an application through prescribed pro forma, your application will not be considered, and that has been followed by the previous coordinate bench thoroughly in all the matters. So unless there is a prescribed pro forma, because the order passed by the previous
This is a prescribed pro forma, isn't
yes,
it?
now
Page
it has to be
47,
yes, correct. It has to be made afresh because since learned the previous single judge has directed in accordance with law. So it speaks of
He has taken printout of the application
previous.
Yes, this will suffice. This will suffice. It is the same thing.
Yes.
So,
your lordship, order of this honorable court, page 55. That is nothing, man. That was not,
please come.
matter was not hard.
The petitioner's application seeking the petitioner is a physically handicapped candidate. Stop. He or she Monoranjan. He seeks transfer. Stop. His application has not been considered by the school authority till date. Stop. The petitioner is directed to forward a copy of the application. Now, of the document annexed at pages 47 and 48 of the writ petition, along with all supporting documents to the school authority for consideration of the prayer of the petitioner for transfer. Stop. The school authority shall take a decision on the prayer made by the petitioner strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of submission of the application, along with all supporting documents. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, then necessary consequential steps in accordance with law shall be taken by the school authority. Disposed.
No, my lord, your lordship direct the school authority to pass a reason order.
Yes.
There is no reason.
Suppose the school rejects.
No, there is no provisions how they reject the applications.
All right. The school may come up with some. It is not that it is a post office and anything goes before the school will go to the DI. This cannot be done. The school, there has to be some level of filtration.
I have challenged them.
That is
why I have served upon the school authority. Why the school has rejected my application?
That is the filtration process, and the school should make you know as to why it has been rejected, isn't it?
And my lord,
yes.
My lord, 8 weeks, my lord, physically handicapped candidate.
Right now, the BLOs are function. The school teachers are all BLOs. Yes. They will take some time. It is only for this reason. Otherwise, I could have reduced it to 4 weeks also. But keeping in mind this work that they are doing, I am fixing it up for 8 weeks.
Yes, next. As per the 3rd January, clear provision, SMC will not reject any application. Even
all right.
It is the physically handicapped. Any application on distance ground.
Yes, next. 26.
Single teacher, whatever. 26, I am for the petitioner. My lord, the petitioner applied on medical ground, pending before the school, but the in prescribed form. Now the school, after the filing the writ petition, school has given NOC. Your lordship, my lord, direct the school to forward the application since school has given NOC subsequently.
Please come.
This is, my lord, exactly, my lord, after giving NOC, your lordship, my lord, pass this order. This is also medical ground. No objections, my lord, was issued subsequently. এই দেখো এই আগের ভিডিও সার্চে দিয়েছি, এটার ভিডিও সার্চ পরেরটা দেখো কি আছে।
Yes, same order. Disposed.
এটা কি অফলাইন মানে 27 petitioner applied my lord on medical ground with NOC. Page 60 my lord NOC has been given, and thereafter my lord the school did not forward, but the petitioners my lord with NOC my lord sent to the DI. That is page 56. After obtaining
Same order will go down in the earlier matter. The school has to forward. You
school has
cannot
given
do it.
NOC.
Hey, ঠিক আছে, very well.
No,
এর আগে
DI
তো
কি
যে
forward
order হলো
করবে?
না
এটা তো DI এন্ডে পড়ে আছে।
26 এ
এটা ডিরেক্ট করছে টু দা
same order 26 এ একটা ফরম্যাট কপি দিলাম,
এটা করছে
26 এ same order.
আগের অর্ডারটা দিয়েছি না, এই যে আগের অর্ডার দে, এই যে this is
Same as 26. Yes, next.
my lord, this is page 44. Petitioner application is pending at the DI office. My lord, kindly direct the DI to consider it. Page 44. আরে তুমি তো বাবা এসএসসির হয়ে তুমি এত অবজেকশন দিচ্ছ কেন?
Page 50 kindly come. Page 50.
50?
NOC is pending now. This is the page type.
No.
Where?
This is the subsequent application. Page 50. 50?
Yes.
50?
Petitioner made subsequent application. Now he is pressing for the first application. Prayer was made for issuance of NOC.
Yes. That is the my lord, the subsequent application.
NOC has not been issued by the school authority.
But you'll also can see page 44.
They have an official seal of the headmaster, headmistress, teacher in that.
Page 44.
Page 44 shows that the head of the institution forwarded it to the DI.
No, up to the school service commission. You'll also see page
Where
45.
Oh, 45 is
Page
there.
45, serial number 11. Petitioner, serial number 10. Petitioner's application to the HOI to DI again HOI. No, page 44.
No. It is
page 6.
Page 40.
Page 6. Well, page 45.
Yes, it is pending before the DI.
Pending before the DI.
Right.
But then, my lord, she subsequently made another offline application.
That's true.
She is continuously going on making applications. What can be done?
Then, my lord,
The kindly direct the DI to consider.
DI stage আছে। DI will consider the order আছে, একটু জেনে নেবেন। You have that order? The DI stage? No.
DI stage no.
Yesterday, many orders were passed. একটু দেখে নেবেন।
DI to consider 8 weeks.
All 8 weeks I'm keeping only because of this SIR work that they are doing. $29.
20 ML this is my application. Well, in this case, my lord, the petitioner.
Side. Yes.
Well, in this case, my lord, the petitioner under compelling circumstances paid the some amount for granting pensioner benefit, which was allegedly overdone, my lord. Thereafter, my lord, the pensioner payment has been issued by the authority concerned.
Give me the copy of the order.
Yes, my lord. The similar order following your lordship's order, my lord, Mita Das Dev, Honorable Justice Mita Das Dev also passed the order, the similar order, my lord. I have corrected, my lord, sorry, my lord, necessary correction. And following your lordship's judgment and as well as the Justice Mantha's judgment.
Where is the order passed by this bench?
My lord, this page, my lord, the order, my lord.
You don't have? Very well, I have it.
Yes, I have with me. I am giving her. Yes.
শুনুন, ওভারড্রলের একটা অর্ডার। ওভারড্রল বললেই মনে হয় পেয়ে যাবেন। এইগুলো ফেরত দিয়ে দিন, সব গুলিয়ে যাবে। নেক্সট ডিসপোজড।
30 I appear.
Yes.
I think
Let me hear. Yes.
Whether the additional 3% increment.
Yes.
This was the now the present issue. Initially, my lord, after retirement, there was direction for overdrawn amount.
Yes.
I came before this court challenging only that portions of the overdrawn directions. That was set aside, court directed to refund the entire amount. I have received it. Now, my lord, the refixation is not being made in terms of the setting aside the order of the 3% additional increment, which are directed to be refunded. So, my lord, only refixation is required to be made in terms of the judgment of the single bench as usual as division bench. This is the prayer I made before the authority, page 30.
Page 33 is a representation.
30.
30. What is the affidavit you want to give over here?
According to this page 5.
No, today he prays for consideration of page 30. What affidavit will you give?
Consideration?
Yes.
No.
Please come.
The refixation. Madam, refixation is required to be made in terms of, my lord, the
Is it there in your representation?
Yes. Everything
is mentioned.
Everything has been.
Please come. The petitioner prays for consideration of the representation dated 26th August 2025.
But I am not praying for consideration, refixation. Your lordship can
Seeking refixation of his pay scale.
Order.
Where is it? Where is the seal of the district inspector of schools?
Madam, page 30.
30
Commissioner of the School Education and Director of School Education.
Where is the DI's seal? It is the DI who will consider.
This by posted this, no?
Then where is the postal receipt?
It is yourself.
Let me see. Degi. Yes, to the district inspector of schools, Malda. And you did not attach this? Acha likhun to. Track report is also not there. Acha ki bollam? Yes. Stop. The said representation is alleged to be kept pending before the District Inspector of Schools, Secondary Education, Malda. Though the receipt showing submission of the representation in the office of the District Inspector of Schools is not annexed to the writ petition, but the learned advocate for the petitioner has produced the postal receipt in original to show that the copy was put to post. Copy of the subject representation was put to post on 27th August 2025. Stop paragraph. The as it appears that the issue regarding fixation of pay is pending before the district inspector of schools, comma.
Fixation already done. Refixation.
Refixation.
In terms of the after setting aside the order and judgment or decision of
refixation of pay is pending consideration before the district inspector of schools, comma. Accordingly, the instant writ petition is disposed of by directing. Where is the setting aside over here?
Madam, I have said, Madam, your lordship kindly page 31.
You've not annexed it?
The order?
Not the order, the setting aside.
Memo.
The initial one, in the other matter, it was annexed.
Yes, Madam, it was annexed.
Then here it is not.
Madam, yes, Madam, page 22.
22.
Page 22. March 2017.
কি বললাম? The district inspector of schools to consider the prayer of the petitioner for refixation of his pay in accordance with law and in line with the memo number 292 page 22 তে আছে, dated 22nd March 2017.
Division bench judgment may be quoted, my lord, otherwise again there are 5 year lordship judgment, it has been quoted.
Where is that? দেখি কি দিচ্ছে?
ওই দিলাম ধরে বাবা এই না এখানে বলা আছে ডিভিশন বেঞ্চ না সিঙ্গেল বেঞ্চ ডিভিশন বেঞ্চ কোট করা আছে মাইলরের জাজমেন্ট
and in line with the order passed by the honorable division bench on 7th January 2025 in FMA number একটু দেখে নেবেন
ওটা দাও না
এই এতটা অবধি and others পর্যন্ত ঠিক আছে
কাঁদছিলাম না
দিয়ে লিখুন an opportunity of hearing shall be granted to the petitioner for production of all documents in support of his prayer for refixation of pay. A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, comma, then necessary consequential steps shall be taken without any further delay. Disposed.
Yes.
থাকবে next 31 yes
the interest on gratuity, but the petitioner was a physical instructor of South Sundarban Educational Cultural Society under the mass education. My lords are determinations.
Are you all? Yes, but then PPO has been issued.
Yes.
You retired on 23. It was issued in 24. Yes. দেখি কি দিচ্ছে
only one of the gratuity and arrear pension. You will also kindly one of the
yes disposed. Disposed.
You want it.
Thirty-two.
This is in regard to 3% additional increment. My lord has passed this order. The lordship, my lord, the only instead of appropriate authority to also direct the commissioner of school education.
এটা কিছু করেছে ম্যাটারে পেয়েছে
Very well disposed.
My lord, in this matter, I am led by Mr. Bosho. Today he has come due to some urgent
I have
cases.
sent him home.
You know, my lord,
him take
he has not come before your lordship because of that.
নামটা দিয়ে দেবেন তো?
Yes, yes, I have given the slip.
Yes, next.
Deeply obliged.
For the 33 of the petitioner, this is the case of the family pension in respect of divorce daughter, pre-81 case. The issue regarding the family pension in divorce daughter pre-81 case has no longer in residue. Because of the larger bench has been passed by the order which is upheld by the Supreme Court. And this is all the Supreme Court business. So, paragraph 18 and 19, my lord. In our page 13, the bottom one.
Yes, respondent.
Yes, Mala, I'm for the statement.
What is your submission?
Well, just now, yes, today morning, I'm received the instruction not given, Mala.
The petitioner claims to be a divorced daughter of a teacher who was in service of the school.
The paragraph 3, my lord. The mother was the employee. Chok Gopal Sarada Vidya.
She died on 5th August 1978. Stop. The petitioner prays for grant of pension in her favor.
Family pension.
Family pension. Answer. Whether the divorced daughters of the deceased of the employees who expired prior to 1991 was taken up for 1981. 1981 was taken up for consideration by the court, and the special bench of this court delivered a judgment on 20th June 2023 in the matter of the court categorically held that the benefit of family pension can be extended to the unmarried/widowed daughter. Where is the divorce coming in?
The page 13, page number 13, the last paragraph.
Page number 13.
From the memorandum, as above, the clearly explicit from the legislature intent to extend the benefit of family pension unmarried widow divorced daughter of an employee who retired before or after 1st April 1981 or to unmarried widow divorced daughter of the family pensioners. In such premise, the memorandum dated 1st November 2020 should not stand in the way
unmarried widow daughter, divorced daughter. বললাম সেন্টেন্সটা একটু বলুন তো নেব ওই আনম্যারিডটা তুলে দিন divorced daughter of an employee Oh, retired before 1st April 1981. Stop. In the instant case, the mother of the petitioner expired prior to 1st April 1981. Stop. Next, in view of the above, the benefit of family pension in terms of the death cum retirement benefit scheme, 1981 ought to be made applicable in case of the petitioner. Stop. The instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, South 24 Parganas to consider not consider, to take steps for grant of family pension to the petitioner, strictly in line with the judgment referred to herein above, at the earliest, but positively within a period of 4 months from the date of communication of this order. Stop. All necessary steps shall be taken so that the petitioner receives the family pension within the time limit mentioned herein above. Stop. The
pension should be started from the date of divorce, not before. That is divorce.
Yes, yes.
Date of divorce 2018.
Where is it?
Page 21.
21. Decree is there?
Yes, decree has been date order dated 6th April 2018.
The pension, family pension, shall be payable to the petitioner on and from the date of decree of divorce, being 6th April 2018, passed by the learned district judge, South 24 Parganas, in matrimonial suit number 1627 of 2017. Page 21, you'll get the details. ঠিক আছে? Very well disposed.
One line, that this order by the special bench has been appealed by the Supreme Court. Otherwise,
special bench যেখানে বললাম না, duly upheld by the honorable Supreme Court. In তাহলে একটা Supreme Court এর order দিয়েছে, SLP number date. Yes, next.
Here is one supplementary affidavit and affidavit service. But Mr. Bhotla is appearing my leader.
Served?
Yes.
Who is your other side?
My lord, I am for the state. But I have served the school also. We have served the school.
All right.
So this is
My lord,
pension benefit. Family pension.
my lord, family pension, my lord. The petitioner's wife, my lord, was a group D staff. She died, my lord, before superannuation. Now, my lord, this we have proceeded with, but on last week we have received an information.
Supplementary.
Yes.
Supplementary affidavit, my lord, the objection has been raised on why?
Page 5. Page 5. Page 5.
Your lordship kindly see. My lord,
Serial number 3.
Serial number 1. Your lordship
Three.
kindly first see serial number 1.
Oh, acha, one thing.
My lord, the last round found correct and after proper verification. Number 2, employees concerned and found correct. Then only 3, my lord, there is an objection. Point number 3, there is only objection. Your lordship kindly come to
1, 2 দেখে নিচ্ছে
1, 2. Then 3, your lordship raised the objection. Then 4, found correct after proper.
All right. So it's a pay fixation. It has been held back.
Yes. Kindly come to
page 19.
Nomination to
Malad, kindly come
AC
to
of pension.
Page 19.
Malad, kindly come to page 19 of the petition. And kindly come to yes, column number 6. Kindly see.
Yes.
The date of joining is 8/10/2013 and 2nd May 2000 notionally. My lord, in paragraph 8 we have stated we are foregoing the notional benefits. Till date I have not. So based on joining report, my lord, the family pension be give it to us. My lord, they are saying
If my calls from my lord, my lord finds sense of judgment or let the
Please come.
We are foregoing.
The petitioner
That is stated.
is the
Husband
husband
of the deceased.
of the deceased teacher. Stuff.
Employee. This is Gupti stuff.
Oh, acha, employee of a school. Stuff. He prays for
Family
grant
pension.
of family pension.
Yes.
Stuff. An objection was raised by the
District Inspector.
District Inspector of Schools, Birbhum.
Yes.
With regard to pay fixation of the employee. Stuff. Paragraph. Reference has been made to the office memorandum, being the appointment letter of the employee.
Approval memo.
Acha, approval memo.
Yes.
Approval memo of the employee dated 7th October 2013.
Yes.
Stuff. Paragraph. Now we can likhun. Column 6 of the said memo mentions the date from which the appointment is approved. Stuff. The approval was given from 8th October 2013
Grateful.
and notionally from 2nd May 2000.
Yes.
Stuff. Learned advocate for the petitioner submits that the petitioner foregoes the notional benefit
Why not?
and only prays for issuance of the benefit after taking into consideration the 8th October 2013 as the date of
joining.
approval of the service of the employee.
Grateful. Lord.
ঠিক আছে?
তো তুই এক মাসের মধ্যে বলো বলো না দেরি হবে
Where have you foregone it? Which paragraph you said?
Yes.
Paragraph 8 and 9.
8 and 9.
Paragraph 8.
Achha. The
Verbally, your petitioner was requested to forego the national benefit, and admittedly, no benefit was given to her, wife of her, during her lifetime, and your petitioner have also given such consent thereby.
the averment of foregoing the notional benefit is mentioned in paragraph 8 of the writ petition. Stop. Next.
So within a month. No dispute, kindly give us within a month. Follow now.
As the employee expired more than 2 years
Yes.
back,
Yes.
and the petitioner himself is a senior citizen,
And his daughter
the
is a
district
student.
inspector of schools ought to take steps to regularize the family pension file of the petitioner in accordance with law. Stop. The instant writ petition accordingly stands disposed of by directing the district inspector of schools, secondary education, Birbhum, to take steps to ensure that the petitioner's family pension file is made ready without any further delay, and the family pension is disbursed in his favor. Stop. Without any further delay, it
First steps to be taken within fixed time.
is made ready and it is disbursed without any further delay. দুবার করে তাহলে আর বলতে হবে না. Steps shall be taken by the district inspector of schools at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
8 weeks বলো না.
12 weeks cooperate.
Yes, already all cooperated.
The petitioner is directed to render all cooperation
8 weeks.
With the district inspector of schools for making ready the family pension file.
All 8 weeks.
Can it be done?
Supplementary affidavit filed in court is taken on record.
Can it be done within 8 weeks?
Well, we are suffering. Why not?
I can understand you are suffering, but then these people are they are involved in the SIR. That is the reason I am giving a little bit more time. Next.
35 months of
Yes.
for the petitioner. This is the widow has come before lawsuits. Husband died prior to pronouncement of Abhijit Vaidya's case. The series of order passed by your lordship.
Yes, give.
Well, I have My lord, I have corrected necessary, my lord.
My lord, in
Lordship.
this matter, my lord, the husband of the petitioner, my lord, died in the year 2010.
Yes.
And my lord, thereafter, my lord, no such steps has been taken, my lord. Only on 16th September 2025, one representation has been made, my lord, and this petition has been filed. I am yet to receive, my lord, any instruction. My lord, if your lordship, my lord.
All right, disposed of same order. Next.
Much of it. It is 35.
And 36, Lordship, I'm praying for not to, Lordship.
Why?
Primary matter is going on. In primary matter is going on 14 number 11, Lordship.
This is not a primary matter.
My senior is appearing here.
Oh, you can do it. Yes, what is it? What is your prayer?
Lordship, your Lordship, petitioners are pursuing candidate of special B.Ed course, Lordship. Petitioners are pursuing candidate of special B.Ed course, Lordship.
Is the microphone working? Take the other one. Yes.
Lordship, petitioner pursuing candidate of special B.Ed course, Lordship.
Yes.
Subsequently, Lordship, petitioner tried to submit their application, but they failed, Lordship. Because there is a notification, Lordship.
Application for what?
Application for participating in a TET exam, Lordship.
All right.
There was a notification, Lordship, issued by the West Bengal Central School Service Commission. It says that
Commission who is appearing?
Lordship, have served.
Anybody for the commission?
There is a similar order passed by the Honorable Justice Shogata Bhattacharya, Lordship. They have allowed, Lordship, I have annexed the order, Lordship. Have allowed page, Lordship, 92 to, they have allowed the similar circumstance candidate, Lordship, to submit their application by offline mode, Lordship. So I'm praying the similar prayer, similar order, Lordship. The notification says, Lordship, the qualifying B.Ed candidates can participate in the exam, TET exam, Lordship. But there is a regulation.
Dr. Patro is here or not? There, you called. Are you not aware of this matter?
But there is a regulation, Lordship. It says that a person pursuing any of the teacher eligibility course, Lordship, can participate in the exam, Lordship. That page 67.5, Lordship. A person who is pursuing any of the teacher education courses specified in the NCT notification shall be eligible for appearing in the TET. May I read the order, Lordship?
No, I am reading it.
The 11 page, Lordship, page 95.
Do you have a copy of the rate?
Absolutely.
But then the dates are long over, possibly. I do not know. Because this order was in September. And the application was permitted to be filed immediately on the next date. That means there must be some urgency in the matter. And still now, can this be allowed?
So 24th was the last date.
That is the reason by 25th the court permitted.
Allowed?
Yes.
Do it?
Right.
The next day the court allowed up to 1 p.m. that we will accept their
Yes.
Offline mode, Lordship.
Offline, but then
in
today.
online mode. In online mode, but this order says in offline mode. You can.
Yes, and you are coming long after. So why will your prayer be allowed?
Lordship.
What is the
because yes,
reason to allow your prayer when you've come long after this date is over?
Here, 25th September is the Lordship. They have allowed, Lordship allowed that in offline mode pursuant to notification such as by tomorrow, 25th September. Lordship condone the date, Lordship. Because 24th
By only half a day.
Yes, Your Lordship.
Today you are coming on 4th of November. How can this be allowed? Let your senior come. I'm passing it over, not dismissing in your presence.
Lordship,
Not dismissing in his presence.
Not today.
Not today.
This writ was filed on 30th October. 30th October. That is after the
Yes. Right.
Yesterday, one matter was heard by the division.
All right.
And without creating any precedent, the court has directed us to allow one candidate to fill up the form. That will be done tomorrow at 1 p.m.
All right.
But the reason was that because the candidate had approached the court when the portal was still open. It was filed on 20th.
I have expressed my mind that the petitioner has come here long after the portal closed. So why will it be allowed?
That was within time. That is only why one matter.
That is gone.
Yes.
But then dismissal in her presence, I won't do. Let the senior come.
Tomorrow.
You want it tomorrow? I'll fix it tomorrow. Only not today. Tell him what the view of the court is so that he can come prepared. Next.
In this matter, I am for the
School authority. School authority.
This is the affidavit of service, my
State, my lord. Yes.
My lord, fact is that, my lord, in the year 2006, the post of clerk, unreserved category, was
My lord.
vacantly.
I am praying for 1 week adjournment.
Why?
I have received the brief actually yesterday.
Yes.
So I have to take the instructions from.
Did you go through the brief?
No, my lord.
Why? Are you there in the panel?
No, no.
Who is there? You said you were appearing for the state?
Yeah.
Orgo Chaudhary.
Come forward. Please come forward.
Microphone.
Orgo Chaudhary, my lord.
So you are not there?
No, no.
So I am appearing for the state is not the right submission.
My lord.
What should be the submission?
Led by.
I am holding brief. You are not led by. Since you are not there in the panel, you cannot appear. You can hold brief on behalf of somebody. Got it? So you are holding brief on behalf of somebody. Assuming you are holding brief, the moment you get a copy, please go through it. Right? Yes. What is it?
In the year 2006, prior permission was given to the school authority to fill up a vacant post of clerk, reserved general category. To the effect, the school authority approached the concerned employment exchange and employment exchange that sponsored the name, including the name of the petitioner. And my lord, in the year 2008, interview was held. That is on 13 January 2008, my lord. But no panel was prepared. So one candidate approached this honorable court and filed a writ application being WP number 19053 of 2015.
Who is for the private respondent?
I am for the respondent number 7, Lord.
You are there. All right, yes.
And my lord,
did you file your wakalatnama?
Yes, in the department.
And by the solemn order dated 14th September 2015, that was disposed of. Kindly come to the order. Annexure P2.
Yes.
This honorable court was pleased to direct the school authority to hold the interview afresh by the same set of candidates. Kindly come to the page started from page 31.
Yes.
Mr. Tarun Kumar Das, learned advocate, appearing for the petitioner, submit that though pursuant to the prior permission.
Wait, 1 minute. The justice Yes, then what happened?
With the same set of candidates who was sponsored by the employment exchange. But subsequently, in the year 2005, this year 2025, selection was held with there a new candidate appear. That is the respondent number 7.
2015 order
Yes.
complied in 2025.
My lord, this is the school authority will say, my lord.
10 years. What is the consequence of
Thereafter, the contempt application already filed, that is also pending. Thereafter, the matter also the appeal also pending. That is also pending. That was all what withdraw. Thereafter, what happened, Lordship, my lord, my line of says, Justice Somasruti Chatterjee passed an order along with others, petitioner, that is respondent number 7, along with other to appear interview. Interviews are held. Panel.
No, page 32.
Lordship,
Page 32.
Mr. Kanailal Samantu, learned advocate.
Yes, thereafter.
Page 32. I am of the view that justice would be subserved if the school is directed to hold fresh selection on the basis of the prior permission already granted with the same set of candidates. How could you permit somebody new to come in?
Thereafter, he filed respondent number 7, filed an application before the High Court, that is Somasruti Chatterjee passed an order. He, along with others, to
Where is that order?
Lordship, that is, here is his statement, Lordship, school authority give it the statement.
One thing more, my lord, respondent number 7 is a member of the managing committee, present managing committee.
Wait.
Lordship, can you page?
Resign, Lordship.
1 minute, page.
Page 14, Lordship, can you see? Page 14. Statement of fact.
All right, then.
Then, selection process was held.
1 minute. Yes.
Lordship, thereafter, he appeared, and along the others appeared 39 call letter issue, only 24 appeared. Thereafter, Lordship, interview was held and released prepared the list and said to the additional district magistrate, district inspector.
When was
that is 52.
When was the interview held? In 2016?
2025 to 25. After the mat was withdrawn thereafter.
All right, then.
Lordship, kindly 52 page.
Yes.
Lordship, kindly see 52, the list. Petitioner, that petitioner is item number 9, that is 24. He's appeared. He's known of zone of consideration. He's not appeared in the zone of consideration. How did the local senate to file this application, Lordship? First thing. Then the second thing was enter list of the before phase, Lordship. Enter call list letter, that is all candidates not appeared, that is 36. All candidates participate in interview. Selected, they are not selected. The selected candidate, that is additional number 7, along with another 2, that is first, second, third, sent to the ADI. ADI is the first, second, third, and Lordship, that is my information, audio and record. Item petitioner number 3, that is third position, he filed this application, and that is dismissed for default.
There is one writ petitioner over here.
That is one petitioner, that is respondent number, serial number, that is 24, Lordship.
Another person.
That is different.
That is different.
Yes.
All right, I followed.
While kindly consider the order passed by the Honorable Justice, Somasruti Aziz Lordship, with the same sort of candidate, without.
That was on 14th of September 2025.
My lord.
The school is relying upon another order which was passed on 14th of December 2015.
My lord, kindly consider. This was.
So this is afterwards. Were you aware?
No, my lord, I am not at all aware.
Then what can be done?
My lord, kindly come to the paragraph 13. Who is the respondent number 7? He is the member of the managing committee.
All right, please come.
He resigned already.
Already resigned, Lordship, already joined. Already appointment letter, he joined, and this is the salary.
The petitioner contested in a selection process. for appointment in the Group C category in a school. Step. From the documents annexed to the writ petition, it appears that in respect of the same selection process, a writ petition was filed by one Shubhendu Vikas Das. Shubhendu Vikas Das, being WP 19053 within bracket W of 2015, wherein the court passed order on 14th September 2015 directing the school to hold fresh selection in respect of the post of clerk on the basis of the prior permission granted by the Additional District Inspector of Schools within bracket secondary education, Kontai, Purva Mendipur, with the same set of candidates within a period of 6 weeks. Paragraph. Submission of the petitioner is that the school authority conducted the selection permitting candidates who were not sponsored by the Additional District Inspector of Schools as was directed by the court on 14 September 2015. It has been submitted that the private respondent who has been found to be securing the first position in the panel was not sponsored by the Additional District Inspector of Schools.
Not by the concerned employment exchange, my lord.
Just not sponsored by the employment exchange. Prayer has been made to set aside the selection process and cancel the candidature of the private respondent, as the same is contrary to the direction passed by the court on 14 September 2015. Paragraph. Learned advocate representing the school relies upon documents in support of the submission that the private respondent was permitted to appear in the selection process in compliance of the order passed by the court on 14th December 2015 in WP 28952 within bracket W of 2015 within bracket Devdulal Mondol versus State of West Bengal and others. Others, wherein the court directed that the school will allow the petitioner, that is Devdulal Mondal, to participate in the interview if he is found otherwise eligible. As the private respondent was found to be eligible, the school permitted him to participate in the selection process. The school has placed before this court the consolidated score sheet in support of the submission that 39 candidates were directed to appear for interview, and a panel of 9 candidates was prepared. Not panel. Appeared in the interview, appeared in the interview, and the private respondent secured the first position. Stop. The consolidated score sheet was forwarded to the District Inspector of Schools, ADI, Additional District Inspector of Schools, for approval, and the same stood approved. And the private respondent is currently serving in this school.
My lord.
Stop. Appointment letter was issued in his favor on 20th August 2025, and the private respondent joined the school on 25th August 2025. The appointment of the private respondent stood approved on 24th September 2025. Stop. Next. Upon hearing the submission made on behalf of the parties and on perusal of the documents placed before this court, it appears that though initially the court directed the school to conduct the recruitment process, selection process, from amongst the candidates in respect of whom prior permission was issued by the authority, but thereafter, vide order dated 14th December 2015, the court directed the school to permit the private respondent to also participate in the selection process if he was otherwise eligible.
My lord.
Stop. The restriction of, not restriction, the direction of restricting the selection process between the candidates vide order dated 14th September 2015 stood literally modified by order dated 14th December 2015, allowing the private respondent to participate in the selection process. Stop. The private respondent was found otherwise eligible by the school and was permitted to participate in the selection process. Stop. The school has conducted the selection process and found the private respondent to be the best suitable candidate. Stop. Appointment letter has been issued in his favor, and the appointment of the private respondent stood approved by the authority way back in September 2025. The instant writ petition has been filed on 4th November 2025, that is long after the appointment of the private respondent stood approved. Stop. At this stage, there is hardly any scope to interfere in the matter. Stop. The writ petition accordingly fails and is hereby dismissed. Service is taken on record. Next.
My lord, may it please your lordship. My lord. It is a, my lord, petitioner is a, my lord, age-old school of South 24 Parganas. My lord, this is, my lord, but issue is, my lord, appointment of assistant headmaster. My lord, in 2009, my lord, the school student number was, my lord, more than 700, my lord, nearly 1,000. So, my lord, school took
700 and 1,000, 300 difference.
more than 7,000, that is 1,000 at that time. Now, my lord, school took resolution, my lord, for appointment of assistant headmaster, sought permission. DI has granted that permission. But for the internal issue, the managing committee dispute and some guardian member of that, my lord, that could not be processed at that time. That was postponed. One candidate who was the applicant, one of the applicants, my lord, he filed a writ application. And Honorable Court, my lord, is directed to complete as soon as possible. It is a page 43.
Yes.
Yes. 45 is the operating part, my lord, that is disposed of with only with the observation that the respondent authority must ensure that the process of selection in the post of assistant headmaster be initiated as early as possible, and certainly giving the writ petitioner the proper opportunity to complete the same. This is the situation, my lord, but that was remained hold, my lord, and in 2016, my lord, we sought, my lord, intervention of the district inspector school, seeking, my lord, then to advise and so that we can proceed, my lord, with this recruitment of the assistant headmaster. But the DI part, my lord, that he remained silent, and he that you proceed with the matter and comply with the honorable court's order. But the problem is that the one of the two candidates, one of the that writ application earlier, he got transferred. Now, as of now, today, my lord, only one applicant pursuant to the old recruitment process. Now we are seeking, my lord, prior permission from the DI. Give us, my lord, prior permission so we can initiate.
Where is the earlier one?
Earlier one, my lord, honorable courts, prior permission.
Prior permission.
Prior permission, my lord, page 34.
Yes.
Yes. Now, my lord, in 2015, the new managing committee, my lord, assumed the charge. They felt that due to increased number of students and for smooth administration and management, my
Where is your present request for
yes,
issuing
yes,
fresh prior permission?
First request we have made on page 46. With due respect, I the undersigned and I am to inform you that the student strength of our school is increasing rapidly.
Then thereafter?
Yes. Thereafter, my lord, there is a resolution of the managing committee on the next page. That
right now, what is pending?
Yes. Page 46. Then again, my lord, now final one is, my lord, intermediately there was many other representations. Page 73 is the last one. We conveyed the difficulty why we could not proceed with the earlier one, and now in our school several others eligible candidates are there. There will be a fair chance, giving all them a fair opportunity. So that is to be, my lord,
selection for the post of assistant headmaster.
Yes. May I say this? There is no as such case of inaction made out by on the against the respondents. For a quick recapitulation, when they require an appointment to be made, they ask for permission of the DI, which is given. My lord has seen it, which was given. Thereafter, they should conclude the selection process, which will culminate in a list. Thereafter, the list is to be given to the DI for approval.
No, that has not been done.
Yes. Now the thing is, in 2009, your leadership has seen the order. Now they are supposed to prepare a panel, give it to the DI for approval. What they do instead is, in 2023, for the first time, they write to us for permission to initiate afresh. Why? Because in the meantime, from the panel, 2 persons have gone away, and some other persons who have acquired fresh eligibility. Now they wanted us to do this. We had reiterated that what is to be done in the terms of the order of 2009. They again write to us for fresh. That is the first time they say fresh approval. We say that after 14 years, fresh approval, we are not in a position to grant.
Is it your case that the right now it is page 34 that the prior permission This is to be acted upon.
Yes, because that permission which was granted,
It's still there.
yes, the next step is that they should finalize a list, send it to us.
I get it. So you say, according to the 2008 prior permission, they are to act now.
Yes.
This is the thing.
That action remains to be done by them in terms of the 2009
All right.
order.
And this is in respect of only one.
Yes.
The post of
headmaster.
that is the post of assistant headmaster.
The other has not been sanctioned also.
No, that is not a case. No prayer has been made also.
No
Had it not been
sanction.
a sanction post, the recruitment would not have been initiated.
So, no, the second one.
That was
Second one. One is there.
Yes.
One post is vacant.
Yes.
They want one more.
Assistant. There is only one assistant headmaster in school.
Assistant headmaster, one applicant is now present, only available.
Yes, that is the problem.
Pursuant to earlier one.
They said
now presently there are other candidates, eligible teachers who can they fulfill.
Why don't you conduct a selection process?
That
to
is
do it?
that since after this order, my lord, that one candidate who remained, other Rajaram Patro, he got transferred.
Oh,
Earlier he
maybe
applied.
Patro has gone. Somebody else
But
will come.
we have since it was started and interview could not be processed, but the applicants were there. Applicants were there, my lord. That is the permission.
Petitioner school seeks a direction upon the district inspector of schools, secondary education.
Only one
South
second.
24
Pursuant to that
Parganas.
first prior permission, we can proceed. That is will serve our purpose will be served.
This is what he says, that you can do it.
My lord. That is.
Lordship, Sukomal Mighty had been made
yes.
a party, but Lordship,
No, we
can
are
you
not-
look into their peer? You
Who
would
is
be
he?
allowed to party. Sukomal Mighty.
My lord, he is the previous applicant who had
have not been made a party. But kindly look into this peer, I would be allowed to participate in the election.
My lord, may I clear the air if your ladyship so permits me? May I clear the air? The problem is Shukomol had obtained some rights in terms of 2009 order. Now Shukomol is the only person who remains in the list, and that process has to be concluded now. So Shukomol's chance is automatic and confirmed. Now what they have done, the managing committee has done, they have slept over for many years. In 23, they wake up from their slumber and say that some more people have qualified. Now probably Shukomol does not want to compete with them. And the problem of DI is that since the order is to bring to culmination the previous process, we cannot issue fresh permission. So there is a deadlock over there. And Shukomol being the previous writ petition, it is for your leadership to decide.
We have said that along with Sukomol with other eligible teachers.
Why will he compete? He doesn't want to expand the scope of competition.
That is the problem.
That is the problem. Now the the candidate, the competitor, he left.
Can you look into this space?
Can it be that process is not yet been started? Only applicants were there. That is to.
What was the stage then?
State only.
You were eligible, but then you didn't start the process.
You were eligible.
Now if we can invite and receive the applications from all the eligible candidates, we can start a fresh process.
No, but then 1 minute, page 34, 2008 PP.
Yes.
Did you initiate the process for filling up?
Yes, that is the submission made.
We received the application.
That means you called for applications.
Now only one applicant is
was
available.
initiated.
Yes, now we must be given a liberty to call for fresh applications. That is
yes, so that is a fresh recruitment which goes somewhat against the 2009 order. I leave it. That is the problem.
But only one applicant he will be competing with whom, that is the.
Where is the competition? His right crystallized long back. Since you started the process, you didn't conclude it. I don't know why you didn't take steps for filing.
I have fairly.
That means your client was also not very interested. Why are you here? Did he give wakalatnama to you?
I have not been. Lordship, I will furnish the wakalatnama.
No, you were not a party.
Lordship, I have not been made a party, but kindly look into this prayer portion.
Whatever is
Sukomal will
prayer.
be allowed along with the other. That is why I am making
prayer.
this submission before you, Lordship. Kindly look into the Lordship's order.
Where from did you get the writ petition? From Sharthok?
Sharthok, Lordship.
Sharthok is making things easy for many.
Very,
and these
very
intervention applications are coming up.
For appealing for the state, we at times find similar pleadings in many petitions.
Obviously, copy and paste.
Only one thing which your ladyship may be interested in. In 2026, the present headmaster of the school retires, because that is for the interest of the students.
26.
2026, the
Due to retire.
due to retire.
Headmaster.
That is all from my side.
Time and again we have conveyed the difficulties for what, my lord, the circumstances that recruitment process got stalled, my lord.
কি বললাম? School, to permit the school to conclude the selection process for filling up the vacant post of assistant headmaster. Stop. From the documents annexed to the writ petition, it appears that on 30th April 2008, prior permission was given to the school for filling up the vacant post of assistant headmaster. Stop. A writ petition was filed by one Sukomal Maiti, claiming himself to be eligible to be appointed as assistant headmaster, being WP 5327 within bracket W of 2009. And an order was passed by the court on 31st March 2009 directing the school directing the respondent authority to ensure that the process for selection in the post of assistant headmaster be initiated as early as possible, and to give the said Sukomal Maiti proper opportunity to complete the same in accordance with the rules. Stop. The school did, in fact, initiate the process for appointment of the assistant headmaster, and a panel was prepared wherein
No, my lord, no panel was not prepared.
Panel?
No, selection process was not even started, no interview, nothing, my lord.
With the filing, with the application being called for, the selection process starts.
Yes, but
Then,
after that, my lord, this Rajaram Patra also did not participate, the other candidate.
Now, the school sought for applications from eligible candidates, but thereafter did not proceed with the said selection process. Stop. In the meantime, the candidate eligible for being appointed, one of the candidates,
yes,
eligible for being appointed as assistant headmaster got transferred from the said school, leaving behind only Sukomal Maiti as the eligible candidate for appointment. Stuff. For reasons best known, the school did not conclude the selection process in accordance with the direction passed by the court on 31st March 2009. Stop. With the passage of time, some other candidates also acquired the eligibility for being appointed as assistant headmaster. Stop. The school at this stage seeks for a direction upon the District Inspector of Schools to permit the school to conclude the selection process. Stop. It has been submitted that the said Sukomal Maiti will be permitted to participate in the selection process along with other eligible candidates. Stuff. Learned advocate representing the state respondents submits that the prior permission issued in the year 2008 has not been finalized till date. Stuff. The order of the court dated 31st March 2009 has also not been complied with. Stuff. It has been submitted that the school ought to take steps in terms of the prior permission dated 30th April 2008 and in accordance with the order passed by the court on 31st of March 2009. Stuff. Though, paragraph, Shukamal Maiti has not been impleaded as party in the instant writ petition, comma, learned advocate appears on behalf of the said Shukamal Maiti and submits that the right of Shukamal Maiti for being considered for appointment stood crystallized by the order passed in his favor by the court on 31st March 2009. Stop paragraph. Upon hearing the submission made on behalf of all the parties and on perusal of the materials placed before this court, it appears that the prior permission dated 30th April 2008 has not been cancelled or withdrawn by the authority. Stop. The same remains valid till date. Stop. Next. The order dated 31st March 2009 directed the school to ensure that the process for selection of assistant headmaster be initiated and the petitioner within bracket Shukamal Maiti be given a proper opportunity to complete the same. Stop. The selection process for the assistant headmaster has not proceeded any further apart from inviting applications only. Stop. At this stage, the school ought to take steps to conclude the selection process in accordance with law, in line with the direction passed by the court on 31st March 2009. Stop. Next. As there are several other eligible candidates apart from Shukamal Maiti, comma, the school shall proceed with the selection afresh, permitting all eligible candidates to participate in the selection process along with Shukamal Maiti. Stop. The school shall take steps to ensure that the selection process is initiated without any further delay and the same is concluded positively within a period of 4 months from date. All right with you? Writ petition stands disposed.
Great. Much.
Service.
Oblige your ladyship. বলে দেবেন ঠিক আছে
ওনার নামটা লিখে দেবেন তো কমল মিশ্র কমল মিশ্র লিখে নিন না সুকমল মাইতি MAITI মাইতি বানান Number 7 and 8 of today's list. Commission's appearance has not gone down. দিয়ে দেবে ঠিক আছে yes
I am for the petitioner, my lord. It relates to 10 marks, entitlement of 10 marks.
then I'll post it on the 28th to 8 Subroto Babu list
I am
this
filing my affidavit of service.
please do list this matter on 28th of November 2020
Both, my lord, similar.
which one
39 and 40.
আচ্ছা
Identical.
38 39 and 40
No, 39
না,
and 40.
38 তো হয়ে গেছে 39 and 40 all right 40 service is there
Yes, yes.
আচ্ছা ঠিক আছে
40.
I'm for the no, that is 3% additional increment.
State.
Really may not be instead of appropriate authority, may not be commission.
Who is appearing?
Mr. Pranab Haldar.
Where is he?
He has not come, my lord, today.
He has not come.
Yes.
And how can his name be recorded? His name cannot be recorded. Is anybody assisting him?
I am also stated, my lord. I am also state.
No, but then are you engaged in that matter? Let me see the order. Negi?
কোথায় গেল দিলাম যে এপিডোরিয়াল সার্ভিসটার
দীপঙ্কর বন্দ্যোপাধ্যায়ের ফাইলটা দিন
এটা না আগে যেটা দিলাম
দীপঙ্কর বন্দ্যোপাধ্যায়ের ফাইল
অর্ডারটা
এফিডেভিট অফ সার্ভিসের সাথে অর্ডার দেওয়া হলো এই অর্ডার
আরে কার্ডটা কোথায় ঢুকাচ্ছে দীপঙ্কর
Commissioner of School Education.
Oh, he is yet to apply?
Yes. Only my lord, the Commissioner of School Education. করে আসেনি বলছে আসেনি না আসেনি
disposed yes combined list যাবেন না combined list যাবেন না only this 42 and 40
And for the petitioner, my lord, here petitioner is seeking a direction to set aside the memo dated 24/12/2024 along with another memo dated 16/1/2024 where it was said that HRA calculation, lordship, on the basis of, kindly come to page 53, that with reference to above noted subject, the undersigned is directed to request him to furnish a detailed comparative statement of house rent allowance drawn by Srimati Chakraborty and her spouse with supporting authenticated documents for the period for which the present claim has been submitted, keeping in view the regulatory guidelines of ceiling of the house rent allowance to be drawn by both the husband and the wife in service as planned by the government from time to time. Excess amount drawn, if any, in respect of may be recovered, and then the present prayer is to be submitted to be sent. Now, lordship, kindly, they have given this reference to the notice, that is the next page, 27 February 2009. Lordship, this was the notification, being notification number 46. Here, lordship will find out, page 62, this clause 13, house rent allowance. with effect from 1st April 2009, the house rent allowance admissible to the employee shall be 15% of his revised basic pay, that is aggregate of the band pay plus grade pay and additional increments, if any, in the revised pay structure, subject to the maximum of rupees 6,000 per month. The ceiling of the house rent allowance drawn by the husband and wife together shall also be raised to rupees 6,000. Now, kindly come to the page 65. This is the corrigendum notification dated 27 December 2018. This is under challenge. Now here, my lord,
65 is under challenge.
65 is, my lord, 53 is under challenge and 16, 24 বার হলো। we have challenged 24/12/2024 and 16/1/2024. This was challenged before this court, and page 65 was challenged. And Justice Sharaf passed delivered a detailed judgment, and which is also annexed in page 68. my lord.
Yes.
In the judgment, Lordship, kindly consider page.
So what is your prayer right now?
My prayer is this has been denied, and they said that the recovery will be made. For the my husband is working in the private sector company. I am working in a school.
That means page 53, 24th December 2024, where
this has been directed that excess amount drawn, if any.
If any, did they make any calculation?
As of now, I am not having any instructions.
Yes.
But as from perusal of this page 53, there is no particular order.
Direction for withdrawal, but then it is calculation is to be made. Where are the calculations? What is the requirement of filing the writ petition now?
My lord, I made an application for the arrears, but that has been stayed. That has not been
stayed.
Yes, my lord. Kindly come to page 53.
Yes.
This is the area claim. I made an application for the arrear, and in respect of the arrear claim, I came to know this.
Right. See, it is pending. The ADI from the Assistant Director of Accounts, not ADI, Assistant Director of Accounts to the DI.
Yes.
A comparative statement has been sought for of the petitioner and the spouse.
Now,
right.
They cannot seek this because
husband is working somewhere else.
Private company.
Where is it?
And now, now he has left that job, started his own business.
So he's no longer there in his and in
That's the present status.
He was never a government employee.
No.
Yes. Where is the question of seeking for any comparative chart?
Whether it is a government, as of now, I am not having any instruction. But as per 53, whether the petitioner's husband is a government employee, in that respect, clarification is
He is not getting her areas. That is the prejudice.
Fixes a time-bound period in which the entire matter may be resolved by the concerned.
It cannot be.
Then let me come back with instruction.
Please take instruction as to whether the husband of the petitioner ever worked in any government concern, and whether the service of the husband of the petitioner can be taken into consideration for deciding the house rent allowance of the. The petitioner is aggrieved by the communication dated 24th December 2024 by the Assistant Director of Accounts, Secondary Education, Howrah, requesting the District Inspector of Schools to furnish detailed comparative statement of house rent allowance drawn by the petitioner and her spouse. Specific submission of the petitioner is that her spouse never served in any government body. He was working with private institutions, and his service benefits cannot be taken into consideration for the purpose of calculating the house rent allowance of the petitioner. Stop. Reliance has been placed on the judgment delivered by the court on
11% page 103.
16th March 2021 in a batch of writ petitions, first of which is page 67. Please take down the number and the name.
Relevant paragraph 14, featured in internal page 16. Therefore,
Especially paragraph 14 of the same.
The same question was decided. And this was
Stop.
decided in 37-101. This question was decided, answered by this court.
Learned. Paragraph, which paragraph you said?
Paragraph
40.
14 is the question framed by the
Achha. And answer is 47.
This is paragraph 48 is the answer.
अच्छा 48 लिखे दिन तो 14 paragraph 14 and 48 paragraphs. Learned advocate representing the state seeks time to take instruction in the matter. Stop. The district inspector of schools secondary education Howrah is directed to revert with written instruction as to whether the spouse of the petitioner ever worked in any government concern and whether, despite the judgment passed by the court as mentioned herein above, comma, the service benefit of the husband of the petitioner can be taken into consideration for ascertaining the house rent allowance of the petitioner. Released 2 weeks will be all right. 25th November. Not 25th, not 26th of November.
My lord, 26, my lord.
You have any problem?
Any date after?
After 2nd of December.
Grateful, my lord. Affidavit of service.
Yes, service is taken on record.
If we am for the petitioner, she is also, my lord, the 3% additional increment. Your lordship kindly turn to page 31. The 29, this is the upgradation of the school to higher secondary school. Page 31, additional district schools granted 3% additional increment with effect from 1st July 2012.
13.
Second last paragraph.
Acha, 12, yes.
3% he is enjoying till now. Now the 2017 circular, he will be in problem because he is verge of retirement 20th February 2026. You know, she direct them to act on the basis of this.
But then as of date, you are getting it. Why the writ petition?
2017 circular has been set aside 2024.
The authorities know it.
Now the direct
This is a premature writ petition.
No, the
Cause of action is not there.
Every cases, unless the court directs, they will the objection, joint director object that, no, you will refund the amount. Other, you also know there, you also kindly direct them to proceed the pension on the basis of
you got that order? The order that you showed, please come.
The
petitioner.
After refund,
yes. The petitioner is receiving 3% additional interest. Not interest, additional increment for teaching in the upgraded section of the school. Since
as headmaster, madam.
As headmaster, with effect from 1st July 2012, in terms of the notification dated 10th February 2010. Stop. He is due to retire from service on
28th February 2026.
28th February 2026. He apprehends that his papers relating to terminal dues may not be made ready if the authority takes into consideration the subsequent notification dated 22nd March 2017 by কি বাবা এই তো শুনলাম প্রদীপ আসেনি এবার কোত্থেকে চলে এলো it has been submitted that till date the petitioner is receiving the 3% additional increment and no steps have been taken by the authority to reduce his scale of pay. Stop. Next. The issue of withdrawal. আচ্ছা এই প্যারাগ্রাফটা এবার দেবেন তো
46 I have annexed the order.
Only paragraph 5. ঠিক আছে এরপর লিখুন as the subsequent notification dated 22nd March 2017 has been set aside and quashed by the court by the honorable division bench of this court.
No, by the coordinated bench. Page 46.
FMA number is there?
That is FMA.
Then that has been upheld.
Set aside by the coordinated bench, the Honorable Justice Rai Chattopadhyay.
Then that has been upheld.
No, division bench in another case also, my lord, said that the 3% is entitled. But the circular has been set aside by page 46. I have annexed the judgment.
Achha, 46 set aside by the court.
11 portion, my lord, page 56.
Court.
Yes, page 56.
On 15th January 2024. In WPA 6217 of 2021.
56.
Accordingly, the authority would be bound to take steps in terms of the government notification dated 10th February 2010. ঠিক আছে? The authorities shall continue to pay 3% additional increment to the petitioner in terms of the fixation made vide memo number 129 / cannot read দেখে নেবেন কি আছে এটা
that is page
dated 29th May 2017
page 44 I have annexed
31 you showed me.
No, that's 2017 circular I have annexed. Page 44.
No, 44 I'm not concerned. 31, what is the memo number? 129?
31, memo
31.
number 129, yes.
And then thereafter /
my lord, the CGS, Chandannagar, probably. CG, এটা কি? CG?
ঠিক আছে দেখে নেবেন
Yes, yes, Chandannagar subdivision, CGS.
চন্দননগর subdivision, CGS. ঠিক আছে?
Continue to pay along with my lord the settlement of terminal benefits. My lord the
automatically on the apprehension of
this.
This was to be dismissed. Fit case for dismissal.
Yes, apprehension.
Only it's rising time. That is the reason I did this.
Because my matter has been all settled.
হয়ে গেছে 4:20 বেজেই গেছে Oh, there is a Passover matter. Yes, give. 17. কোথায় গেল দেখি? Where is the petitioner?
Petitioner did not come yet.
তাহলে আর কিছু করার নেই।